Lot
But
of
after
of course, they will be
29th of July.
I just wanted to say that since in terms of the Supreme Court rules, notice issued to the Attorney General, and
I think you're the mic.
yes, sorry. In terms of the Supreme Court rules, you'll also issue notice to the Attorney General, and I thought the Lord's permission make some introductory remarks. That is, unless the Lordship say that we'll hear them on the.
They are raising a preliminary objection regarding the tenability. So first, I think.
Lord, very well.
We have said that we'll hear them for half an hour.
Lordship will hear me on maintainability minutes.
And then half an hour, and then we'll start with the process. Then it will begin with your opening.
As your Lordship, please.
Lordship will hear me on the.
Mr. Venugopal argues Tamil Nadu may be given a chance, my Lord, because we had filed a maintainability. Reference stems out of.
Half an hour you have to conclude the hearing
Yes.
on the preliminary objection.
Not after Mr. Venugopal.
I will take on the Lord a very short time.
Fortunately, your Lordship.
स्पीकर है बोल रहा है उसके पास एक एक्स्ट्रा
Order.
May I start on maintainability minutes?
Yes, yes. Mr. Venugopal.
The issue minutes is really covered by a series of judgments of your Lordships. And if your Lordships will be pleased to take the reference itself, which is, my Lord said, volume 3, page 5. Document 5.
Volume 3, page 5.
Page 5 minutes.
Sorry, sir.
May I read that minutes?
Volume 3 of the PDF or
Volume 3 minutes of the
Volume 3 index of documents.
index of documents.
index of document?
Yes, minutes.
This is as common compilation of documents.
Yes.
Which is index of documents.
Yes.
Venugopal, is it captioned as common compilation of documents?
Yes.
Proceed. Yes, Mr. Venugopal, we have got that.
Yes. My Lords, may I just briefly take your Lordships through the relevant passage paragraphs, starting with, whereas Article 200 of the Constitution of India prescribes the powers of the governor and the procedure to be followed while assenting to bills, withholding assent to bills, and reserving a bill for the consideration of the President. Whereas Article 200 of the Constitution of India does not stipulate any time frame upon the governor for the exercise of constitutional options under Article 200. Now, this may not be quite correct because your Lordships may remember that both in the Telangana case and the Punjab case, as well as in the Tamil Nadu case, the question of as soon as possible in Article 200 has been interpreted by your Lordships. And in the Tamil Nadu case, a time limit itself has been fixed. Then your Lordship may thereafter go to the skip.
Tamil Nadu case means the judgment by the learned two judges.
Judgment of?
Learned two judges.
My lords, one is not reported, but I can give your lordship, my lords, the writ petition number.
Petition 333 of
Writ
2020.
petition number 333 of 2023,
Which is the two-judge bench.
which is a two judges bench, which is at page 150.
Requisition number
Punjab-
333 of
150 of,
333 of 2020 is the petition.
no, where is it shown? Is it not formed there somewhere? No, sir, I'll give your lordship the page number presently. The second one, my lord, is the Punjab case. Three judges, 2024, volume 1 SEC, 384,
2024, volume 1.
SEC 384, three judges, and that, my lord, is annexed
Page
24.
1681
at 11681
of volume 29.
of volume 29.
So, SCC 384 at page
Above three judges at page
1681
11681
of volume 29 of the judge.
of volume
of the
29.
volume of the PDF comparison of judgment.
Yes, volume 29 of the PDF.
29 minutes of the compilations, which your lordship will find, my lord, on the left-hand side.
What more?
32 sub volumes. So this is in sub volume number
29,
So volume 29 at page
11681.
11681. The index minutes would show that page at 11681. There are 18,000 pages minutes altogether. And hence the difficulty.
1
681.
Yes.
Now, if your lordship should skip minutes, three of the clauses,
So total how many pages in 38 volumes?
18,000 minutes. Total
Only judgment.
judgments and the written submissions and various other documents.
Yes.
It's an enormous task to trace out each one of the documents. And taking minutes the reference which I was referring to, skip minutes the next three clauses and come to Milad, the fifth clause, 1, 2, 3, 4, 5. Whereas the exercise of constitutional discretion by the governor and the president under Article 200 and Article 201 of the Constitution of India, respectively, are essentially governed by policy-centric considerations, inter alia being federalism, uniformity of laws, integrity and security of the nation, doctrine of separation of powers, and then overleaf, if your lordships would come to the next clause, whereas there are conflicting judgments of the Supreme Court as to whether the assent of the President of India under Article 201 of the Constitution of India is justiciable or not. But there are three judgments, as I mentioned, the Punjab judgment, Telangana judgment, and my lord, the most recent, delivered about 1 month and a few days before this reference, which have decided this issue, that it is justiciable. Then, my lord,
What about 145.3?
145.3, my lord, if my lord, a demand is made
No,
by anyone,
the requirement under 153, Article 153, clause 3 of the Constitution.
my lord, sir, most of the reference judgments, all of them are by 5 judges because that is mandatory. And therefore, it's all 5 judges.
Whether the judgments on which you are relying,
No,
are
these
the
my lord,
judgments- are the judgments by 5 judges?
yes, No, none among them is 5 judges, 2 judges and 3 judges, but my submission is, We have
Punjab is
hundreds-
3 judges.
yes,
Then,
Punjab is 3 judges.
Telangana, the Tamil Nadu is 2 judges.
No, Tamil Nadu is 2 judges. And Telangana is 3 judges.
And which is the third one?
Telangana, 2 judges. Then Tamil Nadu, 2 judges. And Punjab, 3 judges.
So what about the requirement under 145(3)?
Lords, there is a dispute about that because your lordships are deciding a large number of constitutional cases day after day. And it is only, my lords, if a party asks and points out there are substantial questions of law relating to the interpretation of the Constitution, that a question of 5 judges would arise. If nobody asks for it, and if your lordships lay down the law, that irrespective of any party asking for, say, 5 judges under 145(3),
When the Honorable President itself is seeking the views of this court,
yes.
then what is wrong in that?
But if, my lords, the court itself does not believe that it's a matter for 145(3), if the Attorney General who appeared in the Tamil Nadu case did not believe that it was a 145(3) case, and
Sorry, it was squarely raised, it's part of my written submissions. It's recorded in the
The
judgment.
judgment records that there was a reference prayed for.
Mr. Venugopal, are you really serious on the preliminary objections?
my lords,
Are you really serious?
yes.
Are you really serious on?
You just tell us how
Yes,
do you
very-
overcome 145(3)?
My lord, very serious for the simple reason,
So just point out how do you overcome under 145(3)?
and I'll tell your lordships why. Please turn straight away to the queries.
Yes.
What are the constitutional options before a governor when a bill is presented to him under Article 200 of the Constitution of India? Now, if your lordships would be pleased to take my written submissions, at the end of the written submissions, which is only 8 pages, I have given a tabulated statement putting the query and the place where in the Tamil Nadu judgment, this query is squarely answered.
Mr. Venugopal, we are sorry, we are not again answering our question as to how do you meet the requirement under 145(3).
But let me answer your
When the
lordships.
learned attorney specifically states
Yes,
that it was his contention that in view of 145(3), the matter should go to the 5 judges bench, and that submission is also recorded in the order.
yes.
Then do you not think that your objection is hyper-technical?
Well, also, I would have expected him to have argued the matter and placed it because one has to decide.
Now, please don't interrupt.
One has to decide.
If somebody from one corner goes and somebody from the other corner rises, will not be in a position to complete it. Have some decorum. You are in the court, not somewhere else. You might be used to that atmosphere.
In which case, my lords, one would have expected an argument had to be raised by the learned Attorney General and pointing out to put to the decision of the court that a substantial question of law relating to the interpretation of the Constitution has been raised. Nowhere in the entire judgment would one can find
No,
anything
but
to the effect.
the judgment specifically records that he has taken this objection. And if that is not considered, then is it his mistake?
Nowhere does the judgment say so, my lords, with great respect.
Mr. Attorney, where is your submission of the objection in the judgment recorded?
Both in my written submissions and also where the court is recorded.
It's there in 34L. Para 34L has the submission, has the attorney's submission.
Then if the court doesn't decide it, is it?
Deal with it after Mr. Venugopal. I don't want to interrupt you. I'll deal
I
with
will
the
answer that
query.
question. Is
The
sufficient for the
query.
judge to say it's been raised?
It's been recorded. He's right. AG is right.
34L,
Observation.
It's 20,
My lord,
Mr. Venugopaal, can you
34.
formulate your objection so that we
Yes.
can consider it?
para
Yes, ma'am.
34 small l
34
records the
L.
submission, which, my lord, I'll just read
34
the learned
says-
attorney's submission. He submitted
said
that
so.
exposition of Article 200 as done in state of Punjab is sub silentio as the court, while making the said decision, did not take into account the observations made by the Constitution bench. In last, he submitted that the matter may be referred to a larger bench of this court so as to harmonize the etc.
Therefore, that's what he has said. L, which he has referred to, is a page. May I read that, notes? What he has said at clause L. What he has raised, my lord, in clause L,
He specifically raised that it requires consideration by a judge of 5 judges. If the court doesn't consider it,
may,
can
may,
it be faulted for that?
may I just read what he has raised? He has never raised this of 145.3.
Mr.
145.3 is
Solicitor
not
has,
mentioned any.
he might not have referred to 145.3, but he has specifically referred that it requires to be considered by 5 judges.
No, what he has said
I
is
will
this.
not respond. I will wait.
May I
for
just
my
read, my lord, his clause L. In the last, he submitted that the matter may be referred to a larger bench of this court. Larger bench would be 3 judges. So as to harmonize the observations in BK Pavitra, which is 2 judges, and Valluri Basavaya, which is 5 judges, and State of Punjab.
Mr. Venugopal, can you just formulate your submission so that we can consider what is your
My submissions
objection?
are this. My lord, please see his queries 1 to 11.
Yes.
Each one of these is covered by the judgment in the Tamil Nadu case directly. Now, once, my lords, a judgment covers these issues 1 to 11, these issues are no more res integra. And a series of judgments starting with the 9 judges in the St. Xavier, Ahmedabad St. Xavier case, plus, my lords, the judgments in natural resources, Gavai, Gujarat Assembly have all said that if an issue is already decided by the court, no reference can be asked in regard to these issues because they are no more res integra. Unequivocally, because if your lordships were to decide these issues in a 143, the result would be that so far as your lordships are concerned, your lordships are equally bound, along, my lords, with all under 141 by judgments delivered by your lordships.
So the 5 judges bench is bound by the judgment delivered by the 2 judges.
Unless your lordships overrules it in a case under 32 or, my lords, 136 or 131.
Okay, we'll
Unless
consider
your
that.
lordship overrules them. Now, what he is asking for is for your lordships, my lords, by reason of.
Mr. Venugopal, we have understood your submissions. Yes.
Yeah.
Now let Mr.
All right. Therefore, my lords, by reason of the reference, your lordships at the bench of the Supreme Court is being asked to sit in judgment on another bench of the Supreme Court, which has already decided.
Yes.
And therefore, 143 is sought to empower your lordships to decide, my lords, these questions. This, I say, my lord, is wholly, my lords, outside 143, because your lordships can't touch, my lords, a judgment in 143, which has finally decided these 11 issues. Now, the real reason, my lords, your lordship will find is nowhere, my lords, in this reference is, my lord, the Tamil Nadu case referred to. And this reference is sought within 1 month and a few days after, my lords, the judgment in Tamil Nadu,
Yes.
without seeking review, which, my lord, according to me, the government of India was bound to seek review. Your lords may kindly note that so far as the President of India is concerned, under Article 74, the President is bound by the aid and advice of the Council of Ministers. No area of discretion is left.
Yes,
No area of discretion is given to the President under Article 74. The President has to carry out whatever is advice given by the Council of Ministers. Therefore, in substance and in effect, this reference is by the government of India, but by my lord, mentioning the President as a referring authority, well, that's what Article 143 requires. So please remember that each one of these is an attempt by the government of India, without filing my lord's review, to overturn my lord's, if it is permissible under 143, to my lords, the judgment, my lords, of the Supreme Court, which under 141 binds all. Therefore, I come to the proposition that a judgment of the Supreme Court is law under Article 141.
yes, Mr. Venukumar, we understood that. Now let Mr. Dr. Singh.
No, only one more, my lords. Only one more. That is under 141, my lords, they are bound by all the law laid down by the Supreme
That
Court.
you already said.
Yes,
We
but
have recorded that.
143 is only an opinion. And even if your lordship gives all these opinions, and to complete, my lords,
Yes, we have recorded that. Now let
all
Dr.
right.
Singh make his
Therefore,
point.
my lord, this judgment will still stand,
Yes,
notwithstanding the
yes,
opinion
Mr.
under
Venukumar, we
143.
understood that submission, yes.
Very well, my lords. Very well.
Yes,
That is the reference, that's it.
yes, Dr. Singh.
Yes, sir.
Only 5 minutes left. No, we are bound by the
I'll
time.
take only 10 minutes.
No, we have told you that half an hour for you and half an hour. on
I
this.
will not exceed, but give me some 10 minutes, fellas. I'll not go to exceed. Now, let's please keep 531 open. Allow me to do some speed talking and speed reading.
531 off?
Volume 5.31 of the written submissions. First, fellas, the point-wise answer to my Lord, the Honorable Chief Justice question, then give me 5 minutes to elaborate.
Which volume you want us to?
5.31.
So that's your written submission.
Yes.
Yes, we got it.
In that, fellas,
Yes, sure.
Yes.
5.31.
Page?
No. I'm sorry, fellas, mine is volume 2. My written that 5.31
No,
will be
5.31 is the judgment of the two judges.
with that my written submission, volume 2.
Came last night, 2 points.
Volume 2. So that is the judgment. Please keep volume 2, simple volume 2, which is my written submission at page 4. These two will also keep open. I appear for the state of Tamil Nadu, the only state which went to the Honorable Division Bench, and we succeeded in the order on which now the advisory opinion is sought. If my Lord will keep my written submissions open, in volume 2, at page 4. Now, the point-wise answer to my Lord's queries before I elaborate, because there are two important judgments, the nuance of which your Lordship will profit reading. One, there is, and this is all said by your Lordships in the context of various judgments. No intra-court appeal is allowed. Point 1. Point 2, advisory cannot be a substitute for review. Point 3, advisory
So 1 minute, no intra-court appeal.
directly or indirectly, disguised or not.
Yes.
Number 2, no, 143, not a substitute for review.
That already
And
Venukumar has
review admittedly not filed. in this case. Not filed. Number 3, 143, not a substitute for hurrah and curative. And no curative obviously filed in this case. Number 4, if my lord will turn to page 5 to save time of my written submissions, 5 and 6 have an issue-wise delineation of each issue raised in the reference, which para of the division bench decides this. This is extremely important. Lordship will pardon me for saving time, and I'm not taking your lordship may test it by going to any one para. For example, issue number 1, para 434.1, 434.2, 434.7. Directly deal with it in the conclusions. The reasoning is in the earlier paras 180, 185, 187, 189, 194, etc. Just because I don't have time to read them, please assume in my favor that they deal with it exactly. Every issue, barring issues 11, 12 and 14. Barring 11, 12 and 14, everything is directly covered. Now a word on these 3 issues when I come to the nuance then. 11, 12 and 14 do not really arise because 11, if your lordship will see the issues, is not a standalone issue and the others are peripheral issues. 12 and 14, in fact, not decided because it didn't really arise. They applied the Punjab judgment in the division bench. So substantially every issue para-wise is covered. Now, the nuance. Kaveri is clearly on point in my favor. But a nuance is added by 2G. Naturally, these two judges, lordship will spend 5 minutes on, otherwise lordship will not get a complete picture. Now, my learned friends will rely on parts of 2G, so let me give lordship the point, which is also my Lord Chief Justice's query, and then read those parts. What happens is, if a bench is hearing a matter, if it decides to refer by taking a view on 145.3, it can refer, no problem. If this bench decides the matter and chooses not to refer despite a submission in para 34L by him, then in an appropriate subsequent case, unrelated to this case, unrelated to the list between parties A and B in this case, in a matter between C and D in a subsequent case, your lordship may or may not refer the issue, not the list. However, the A and B decision, where it is not referred, cannot be touched by a so-called advisory view of 143, because that would be subversive of every principle your lordship follows. Now another nuance. That is what this 2G made, very fine nuance. 2G says that you can have a different view on the law, which is what my Lord the Chief Justice is asking. So in a C versus D case, the law may change because your lordship takes a different view. But same 2G mentions that you will not change the list of the decision between A and B in the first case, even by changing the law subsequently. Now another nuance, very important. In the present case, if your lordships allows this the advisory to proceed, your lordship cannot give, even if your lordship wants, your lordships cannot give a judgment. Assume your lordship allows the advisory, that the A and B, which is Tamil Nadu, A and B in this case is Tamil Nadu, stands as it is, and the law for the rest of the country will be C and D. Here, the nuance, that is one of the 2 words used in 2G, is view of the law and the decision in the case. So decision of the case, 2G Kaveri 5 judges say, cannot be changed. The view of the law can be changed in a subsequent order. Unfortunately or fortunately, in my Tamil Nadu case, if your lordship is persuaded to take a different view in 143, both the decision in Tamil Nadu changes and the view of the law changes, which is not permissible. Now come to all of those 2 judgments. Come to Kaveri first. This is the fastest I can do it, but I'll be very fast. 5.14 is the volume. 5417 is the case. Please keep these 8 principles in mind, because this is important when your lordship reads these 2 judgments. Otherwise, these are repercussions. Your lordships is being asked, and let's be very clear about it, without any camouflage disguise, to change the decision, the merits of the decision, the content of the decision between A and B. and not in a subsequent decision, because there is no way your lordships can change the decision in a subsequent decision without affecting this decision of Tamil Nadu. So it's purely appellate, howsoever nicely you may couch it to a 143 court. And that's a very serious, fellows, subversion of Supreme Court discipline, Supreme Court integrity, Supreme Court institutional integrity. These are not rules made just like that. Your lordship has so many of, suppose this is wrong, in an appropriate case, your lordship may refer it. A constitutional bench may sit. But the law will not change for the parties who took it to the other division bench. Because that is concluded. It is inter partes, it is final. It is unchangeable unless in review or curative.
Yes.
The entire concept of stare decisis will be completely subverted, Malas.
Where is the question formulated that we should set aside a particular judgment?
Yes.
We are proceeding on the premise, as we are also sitting in appellate court. We know distinction between 143.1.
Yes.
We know the scope of 143.2.
Yes.
We know Kaveri and 2G scan, the distinction drawn. We are not here on 131. We are in within the parameters of 143.1. And the only issue is that whether the questions raised have been answered or not.
So may I answer? May I answer my last question?
Except for
May I answer my last
3G, except for the 3G decision, the primary distinction between an adjudicatory decision by virtue of judgments stands on a completely different footing from that of an advisory and consistently
That's my
has
submission.
held.
That's my submission,
Therefore, only nuance that has been brought about in the 2G judgment.
which is what I'm coming to straight away. But let me just take 30 seconds to answer Justice Suryakant's query.
Touch that judgment.
So let me answer, Malas, Justice Vikas. Malas, this is the important nuance. The nuance of 2G is that the phrase, these are not my words, the Supreme Court words. The decision cannot be changed. The view of the law may be changed. Right, Malas? No, just give me. Now let me answer Justice Suryakant's query. No, just let me answer. My Lord Justice Suryakant says to me that we will not be touching that decision. Unfortunately, Malas, this is one rare case where both the decision of the case and the view of the law fuse. Let me explain that. There is a complete intersection. Your lordships can't do one without doing the other. And if one is prohibited, the other stands prohibited. Your lordship, all the questions except the peripheral ones 11, 12, 14, if answered other than the way in which the division bench answered it, will constitute a change of law, but a change of law also in the decided case of Tamil Nadu. Because for the simple reason, your lordship's advisory law, which is binding, all admit that your lordship's advisory.
But argument is to accept it. Once there are judgments by court, then everything should stop at that.
No, Malas. Your lordships may find, for example, I mean, this may sound technical.
43
No,
one
no,
is
that-
definitely not binding. It is purely advisory in nature. Let's be very clear about it.
No, Malas. Your lordship's law says that once your lordship delivers judgment,
But
then it is law of the law binding. No,
by
Malas.
a larger bench.
No,
It will
Malas.
be done by a larger bench.
Once your lordship delivers 143, it's a question directly arising, I'll give the judgment.
Says that.
Your lordship's views, because your lordship is the Supreme Court, I can't seek your lordship's advice and disregard it. I can't seek your lordship's advice and disregard it.
The pre and post constitution principles are well settled.
Yes.
143.1 or a principle which was earlier to that effect, it is advisory in nature, purely advisory in nature, may or may not be accepted by.
No, Malas, that's not the law. Unfortunately, that's not the law, Malas. Unfortunately, I would say it's not the law because your lordship doesn't give advisory jurisdiction in futility.
More than 40 minutes now.
No, Malas, but
So the timelines have to be followed.
Malas,
We should have decided between you and Mr. Venugopal. That's true.
Malas, therefore, let me just now turn to, so let me say this, your lordship's view, whatever your lordship view takes in 143 is binding. Let's be very clear on that. Second, your lordship's, Malas, is not, to answer the Honorable Chief Justice, this is not perennial. A matter is referred, the law will change for the future. If a matter, Malas, to give a small example, Malas, Honorable Chief Justice, remember yesterday a matter came. Suppose in an appropriate matter, your lordship refers it. A constitution bench constituted by my lord's reference in that case may decide the law ultimately. It can't be in 143. We are discussing maintainability of 143. 143 is not maintainable. Now turn to Kaveri, Malas, very quickly. Malas, Kaveri, just turn to para 37 at page 8. I'm sorry, Malas, I'm sorry. Show me the mark. Malas, would Malas turn to 19? Para 19 at page 5429.
Of the judgment value.
Yes, that is Malas, volume 5.14. 5.14. Well, otherwise, kindly consider the institutional implications for having advisory jurisdiction on a matter which will change the decision between parties. It becomes a pure intra-court appeal. It becomes a pure review. It becomes a pure curative.
Simply you are proceeding on assumptions.
No, in
Why
the
are you
event
proceeding on assumptions?
no, I'm saying in the
The
event
reference will
accept.
be answered, whatever we, how do you think it's going to change the decision
No, Malas, with respect.
already rendered by the division bench? You are proceeding as if the judgment will automatically be annulled.
With respect.
That's not right.
No,
Why are you presuming on that?
No, Malas, I'm not presuming. Kindly give me.
That's how you are proceeding.
No,
You are
I am
based
saying,
on that
no,
assumption.
we are testing maintainability, Malas. We are testing maintainability, right, Malas? For maintainability,
You are relying on which judgment that it is
if
wrong.
I win in the merits,
Come to the point, please.
well, if I win in the merits,
Come
nothing
to the point, you show us one judgment.
Yes.
Which says that once there is a judgment of a division bench, the reference under 143 is not tenable.
Kindly let us first see this judgment. Because we are talking about advisory. Come to para 19 at page 5429. 5429. Changes can be made, Balas, only in another matter for the future, not Balas in an existing case.
So that's the issue. We are not deciding as to whether Tamil Nadu judgment is correct or not. We are not deciding that issue.
In
We are only answering the reference made by the President.
but in the event your lordship's answers are not consistent with the Tamil
Then
Nadu
we are not
matter,
concerned with
then
that.
it becomes a different matter.
We are not concerned with that. It's
Kindly-
an advisory jurisdiction.
Very well. Let me just read first Kaveri.
So that judgment which says that the reference is not tenable once there is a judgment by
Well,
2 judges or 3 judges.
Yes. Let me show whatever is there very quickly. Two judgments only. Malas. Come to 19. Where, Malas, the tribunal held against Tamil Nadu, the Supreme Court allowed the appeal in 19. Ignore all that. And come to, Malas, straight away para 25 where Karnataka instituted a suit. Let me come to the relevant part. Give me the relevant para. Straight away 83, Malas.
Para 83.
83.
83.
Yes. The
This court by its decision of April, Justice Nath has got it?
Yes.
Chandogla has got it. This court by its decision of April 26, this April 26 is para 19, my lord, the right on the side, para 19, has held as pointed out that the central government had made a reference to the tribunal for the consideration of the claim for interim relief prayed for by the state of Tamil Nadu, and hence the tribunal had jurisdiction to consider the said request being a part of the reference itself. Implicit in the said decision is the finding that the subject of interim relief is a matter connected with the relevant water dispute. Now see from here, Malas. Hence, the central government could refer the matter of granting relief for adjudication. Although this court by the said decision has kept open the question whether the tribunal has incidental, ancillary, inherent or implied power to grant interim relief when no reference for grant of relief is made, it has in terms concluded the second part of the question. This was the earlier judgment of the Supreme Court. It has in terms concluded the second part of the question. We therefore cannot countenance a situation where question 3 and for that matter question 1 and 2 may be so construed so as to invite our opinion on the said decision of the court. That would amount to our sitting in appeal on the said decision, which is impermissible for us to do even in adjudicatory jurisdiction. Nor is it competent for the President to invest us with an appellate jurisdiction over the said decision through a reference under 143. Mr. Nariman contended, however, that the President can refer any question of law under 143 and therefore also asked this court to reconsider any of its decision. That is the direct argument. 143 is quoted. 85. In support of his contention, he referred to Delhi laws. Next line. For the reasons which follow, we are unable to accept this contention. In the first instance, the language of 143.1 far from supporting Sri Nariman's contention, is opposed to it. The said clause empowers the President to refer for this court's opinion a question of law or fact, which has arisen or is likely to arise. When this court in its adjudicatory jurisdiction pronounces its authoritative opinion on a question of law, it cannot be said that there is any doubt about the question of law or the same is res integra, so as to require the President to know what the true position of the law on the question is. Directly on point with this. The decision of this court on a question of law is binding on all courts and authorities. Hence, under the said clause, the President can refer a question of law only when this court has not decided it. The query asked from me, Mills. Secondly, a decision given by this court can be reviewed only under 137. When further this court overrules the view of law expressed by it in an earlier case, it does not do so sitting in appeal and exercising an appellate jurisdiction over the earlier decisions. 5 judges are saying this was. It does so in exercise of its inherent power only and only in exceptional circumstances, such as when the earlier decision is A, per incurium, or is delivered in the absence of relevant or material facts, or if it is manifestly wrong and productive of public mischief. Under the Constitution, such appellate jurisdiction does not vest in this court, nor it can be vested in it by the President of 143. To accept Sri Nariman's contention would mean that the advisory jurisdiction of 143 is also an appellate jurisdiction of this court over its own decision between the same parties, and the executive has a power to ask. If such power is read, it would be a serious inroad into the independence of the judiciary, because the judiciary includes that division bench, this court, everybody. Next, 2G nuance, because that is the main thing which is alleged to have diluted it. Turn to 2G, Mills, which is at page 8123 of volume 5.21. Volume 5.21. So this is crystal clear. Some nuancing was done in a subsequent judgment. So let me place that. 5.21, page 8123. Justice D.K. Jain wrote the main judgment, Mills. There's a concurrence, but I'll only read Justice Jain.
Para 64, 65.
No, but that's correct. That's correct. But there are 1 or 2 more paras, Mills. 8157, it starts. Would my lords come to 8176? Before I sat down.
Yes.
May I invite my lords to 8176?
Yes.
The principal objection to the maintainability of the references, it's an indirect endeavor to unsettle and overturn the verdict in 2G, which is absolutely impermissible. The stand of the objectors is that 2G case is an authoritative precedent in respect to the principle or proposition of law that all natural resources are to be disposed of by public auction. Now, Mills, remember, Mills, in this case, in the Constitution bench, the only issue was whether only way of disposal is auction, because only word is important. Otherwise, it's okay. They were considering an issue not really considered by the earlier bench. At the outset, we may note that the Attorney General has more than once stated that the Government of India is not questioning the correctness of the directions in 2G case. Kindly mark this. No, learned AG is certainly not doing it here, but I mean, this is the law. This is why your lordship doesn't open a decided case. This is what Justice Suryakant is saying, we're not going into the case, but indirectly your lordship is invited to go into the case. That's the whole contention. So here in that case, the learned AG is not questioning the correctness in the 2G case insofar as the allocation of spectrum is concerned. And in fact, the government is in the process of implementing the same. That's not the case here. That's why 2G nuance is not against me. 2G held because another question was raised. Only way of disposal is auction, which was decided anew. It was not a decision on the old matter at all. Therefore, in the light of the said statement, we feel it would be unnecessary to comment on the submission that the reference is an attempt to get an opinion to unsettle the decision and direction of 2G. Nevertheless, since in support the opinion of Kaveri is cited, therefore we will deal with it. Now come to Mills, para 42.
So you can come straightway to para 65. That probably answer what you are.
True, Mills, just 5 minutes extra it will take. I'll just, because otherwise, just 5 minutes extra it will take. 42. 42. Now, Mills, Kaveri is cited over 4 paras. I will not read it. My lord is right. To say that there is no intent in 2G to overrule or dilute Kaveri. Don't read Mills 5 judges in 2G to intending to overrule or dilute Kaveri. Nowhere is there an intention. Now come to Mills. The findings of Kaveri are reproduced in 42 and 43, fully, 42 and 43. Then comes the heart of the distinction, which is between view of the law versus decision of the case. Come to 43 verse. 45. 45. That's the heart of the nuance. Please apply the nuance in another case, not in this case, fellows, is what I'm submitting. The main emphasis of Mr. Soli Sorabji, do my lords have 45 verse? May I read? Was on the second part of para 85, which according to him prohibits this court from overruling a view expressed by previously. We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches of these two questions. These words are sometimes used interchangeably, but not here and above. We believe that Justice Sawant consciously draws a difference between the two when further this court overrules the view of law after discussing the case of a decision. Then come to 47 to save time, although 46 is important also. Blacks explains the difference. 47. Therefore, references in para 85 of Kaveri to decision and view of law must be severed from each other. The learned judge observed that in a case of a decision.
Therefore, what we'll be doing is expressing a view of law.
Correct.
Not a decision in Tamil Nadu case.
Correct. But unlike this case, this is very important query from the Chief Justice. Unlike in this case of 2G, where the issue by the earlier bench was auction and the issue separately newly raised.
This is specifically answered in para 65.
Let me just read first that. Now, 47, my lord, is noted. 47, my lord, is noted.
Yes.
Now, just come to Malas. 48 for a second. Let me first read, then I'll make my comment. The first limitation is that a decision of this court can be reviewed only under 137 and curative and no other way. I'll leave that because I'm doing speed reading. I'm not. Please note the principle of Kaveri is reiterated. Now, Malas, if you say per incurium or Malas completely different, the burden obviously lies with the state. Now come to 49. 49 is the conclusion on Kaveri, which is decision versus view. The conclusion is 56, Malas. Malas, the problem is that your lordships, try as you might.
Why would you come to 65? It's directly answered. Not necessary that all those paragraphs, small five, your junior have to be read.
No, Malas, I'm not even reading half of them, Malas, I can assure your lordships. 63, Malas, and then 65. From the aforesaid analysis,
Yes.
it is quite vivid that this court would respectfully decline to answer a reference if it is improper, inadvisable, and undesirable, or the questions formulated are purely socio-economic or political reasons which have no relation, or are incapable of being answered, or would not subserve anything, etc. Or it is already decided the question referred. Already decided the question referred. That's an important sentence in 63. Then, Malas, come to 65. We are therefore of the view that as long as the decision with respect to the allocation of spectrum licenses untouched, that was the decision of the previous court.
Understand that.
This court is within its jurisdiction to evaluate and clarify the ratio of 2G. For the purpose, it needs little emphasis that we have jurisdiction to clarify the ratio of 2G, irrespective of what we actually choose to do so or not. Therefore, the fact that this reference may require us to say something different to what has been enunciated in 2G cannot strike at the root of the maintainability. Consequently, we reject the preliminary. Right, Wallace? Let's apply this. I have no problem. The problem between this case and my case, the difference is that in my case, if your lordship differs with the heart of the reasoning of the previous judgment, your lordship will be disturbing the decision of the case also. In my case, unlike this case where the decision of the earlier court was implemented in letter and spirit, but the law for the future with only one question was changed. Is auction the only way of disposal? The word only was said, no, there are other models of disposal. That's about it. That's, if your lordships can find a way without disturbing Tamil Nadu to reset the law, I could have no problem. I can't. But according to me, the nature of the case is such that your lordships would have to disturb the decision inter parties adjudicated between the parties, without which your lordships can't do it. That's the also.
Mandamus or whatever, if you call it a mandamus, then the declaration
Yes.
that followed in that case has actually happened. So therefore, the question of our opinion having a bearing on a decision taken does not apply here. It's only an opinion. And we have seen in many cases, in a subsequent case, when you refer an opinion of a court and ask the court to take a different decision as against the previous one, many a times the argument was that this can't be relied on because it's only an opinion. That is what would happen. If somebody would argue on the basis of a decision rendered on an opinion,
Two things.
then it will be only.
Tamil Nadu, the governor is supposed to, I'm giving a very practical example, is supposed to do ABC. He's supposed to decide in 3 months. Your lordship's law tomorrow will change it for Tamil Nadu also in the future. That's about all there is to it.
Yes, thank you.
Obliged.
Anybody else?
I don't want to argue. I want just one sentence, because we in government made the reference in 2G. Therefore, I just want to explain the historical context, nothing more than that. What happened was that the principle of law decided in 2G was that natural resources must be auctioned. So, that happened as far as spectrum is concerned. The difficulty was that there were Mines and Minerals Act, LPG, land, other resources. So the question arose, should all natural resources be auctioned? And the reference was only to that extent, that forget about 2G, that we are following the judgment. Will other resources also follow the principle of law, namely all natural resources must be auctioned? That's how 2G was decided. Just that historical context, there's nothing more than that.
Yes. No, sorry. Yes, Mr. Attorney.
Just note 150 and 152 also. I'm not reading, just note it for lordship notes first. 150 and 151 at the paras of this 2G.
First, to set the record straight, your lord. Couple of submissions I would like to make. I'll place before lordship the written submissions placed before the Tamil Nadu bench and very specifically refer to 145. Because of the judgments of larger benches, which are dealt with the question of 200 and 201. So that's why, but then the judgment does not fully record the entirety of my submission regarding 145.2. So we are specifically referred to 145.3. The last paragraph 11 of this. Page 7, paragraph 11. Can you read it? Having regard to the importance that the scheme of Articles 200 and 201 play in the fine and balanced constitutional relationship between the elected legislature and the governor, it would be of utmost importance that the matter must be heard by a constitution bench, as already outlined above in terms of Article 145.3 of the Constitution. This submission is being made with a view the divergent perspective available in the reading of so-and-so are reconciled, and the scheme of Articles 200 and 201 are duly delineated. In particular, the Constitution Bench judgment of the Honorable Court, Union of India versus Valluri Basavaya Chowdhury, is kept in mind as the said judgment propounds one point of view as regards the process of exercise of duty by the governor in Article 200. You don't want anything more to persuade the court to go under Article 145. Now, let me try to, the 2J judgment has brought in very important perspectives on, I understand if Article 143 is not comparable to any of the other jurisdictions conferred on the court. It is the power and authority of the President. The authority and power of the President is not comparable to say 131, 132, 136, etc. They're all jurisdictions conferred to on the court. But the President, Article 143 says, if it appears to the President that a fact or a question of law is arisen or is likely to arise under public importance, the President is therefore the master of Article 143. And in the course of therefore requesting the court to give an opinion on this question, the court may dwell into the questions. The court may also go into any previous judgments of the Honorable Court and may either agree or disagree. But there's nothing like a threshold injunction against the court to say that we'll not get into Article 143 reference at all. You can't read that limitation in injunction in Article 143. And none of the previous reference, 15 references have come before the court so far, right from M.S.M. Sharma case onwards, Keshav Singh case onwards. The court has gone into previous judgments, but they may disagree or you may agree. So that's why in the 2G case, as the learned solicitor will talk to your lordships, the view of law, the state of law, and the decision. It is being told to your lordship that in this particular case, there's no demarcation, the lines are very, very blurred. Therefore, the both are so intertwined that you can't entertain this 143 reference. I think that's not correct. Even if it is so, the question is whether under Article 143, what the court will do. To enter into the questions, answer a question, decline to answer a question, all that will be matter of practice or procedure of the court. In a given case, if a public importance, the court will say, we depart from the practice because the important question of public importance, and we'll probably look into the judgment 1, 2, 3, 4, 5. Therefore, there is no inbuilt limitation in Article 143, either that will bind the court under Article 143. Look at your old precedent, they are binding on you. 143 does not admit of any of those limitations. Therefore, what you could later argue saying this question need not be answered for good reason because some other judgment has answered it. That's a different way of putting it. But to say the court will not even enter into all of them, I think therefore 143 does not admit of that. I later place your lordship the very first important scheme of Article 143. I just thought as a Therefore, I would say that given the importance in the scheme, in the constitutional scheme of Article 143, the court will probably, to repeat, can even depart from its earlier precedents and how the court will order its practice and procedure of deciding matters under 143. There's nothing like an inflexible rule. Then it will ultimately, if there's an inflexible rule, then the presidential referendum, the president being master of a referendum 143 will completely lose its essence. The court may ultimately say we agree with the judgment. But before that, to say you cannot even go to the extent of saying we agree, disagree, I think cannot be read into Article 143. Recovery water disputes brought is a very important distinction. The 2G notices that decision of law and then the view of law as against this particular a decree or a judgment inter partes. In a 143 reference, the court does not enter into merits inter partes. It's not a list between the parties at all. Parties can be heard in a 143 only for the purpose of assisting the court as to whether a particular question can be answered or not. Beyond that assistance, which parties can lend to the court under 143, the court will probably not say, I'll be heard on the maintainability. I think even the idea of maintainability is wrong in the context of 143. A maintainability issue can arise only when there is jurisdiction of the court. Article 32, 226, 131 review. Is it maintainable? If have you complied with all the preconditions of maintainability, then maintainability comes in. 143 does not admit to the concept of maintainability at all. I would therefore urge your lordships to be given all those 15 long precedents.
It's not one of the foundational principle of 143(1), Mr. Attorney, that when he talks of a question of law, has a reason. These are the preconditions. A
That's
question
right.
of law or fact has a reason. That means a question of law that has not been answered in the past. Therefore, the question of law that would arise for 143(1) will be the one which has not been answered by this court first. And therefore, that question is coming first time to be answered.
Yeah.
So 143(1) jurisdiction will always be at least guided by this principle.
That's true. But therefore, 143 conditions, if you're satisfied, your lordships will go into entering into the question of answering those questions. So even if there is a field occupied by a particular judgment, but if the in public import, the precedent field, I have a constitution-based judgment, I have a 7-judge judgment, I have a 3-judge judgment, I have a 2-judge judgment, which is the one which governs me. Therefore, on a question of law, if there is no authoritative pronouncement or a conclusive authority, the conclusive authority proposition related in the Bala Sahib judgment, give that reference. Therefore, there is no conclusive authority in that question. And there is a difference of views, 7, 5, 3, 2.
To get into the question as to whether the conclusive authority exists or not, then there is a problem. Opinion, if you are asking, it's an opinion, it's all right. No, not every question also need not be answered.
I'm only trying to point out that when you're talking about a question of law, is there a field occupied by a judgment? And therefore, once it is occupied by a judgment, the court will not enter into 140 reference at all. Therefore, in Kaveri, followed by 2G, it says there is a decision or a state of law. I'm going to probably tell you the state of law is a very important concern for the president. I have so many judgments on my table. Which is the correct state of law? 5, 7, 9, 2, 3. Therefore, if a judgment which is a bench of 2 judges, am I bound by it? I am not trying to say that you will overrule it as a review or an appellate jurisdiction. These are all limitations which the court will ordinarily built into Article 143, where we will not ordinarily say review them. Very If you actually look at a later point of time in the Tamil Nadu judgment or the Punjab judgment, we'll be easily able to convince your lordship that the line can be comfortably drawn between what on a particular set of facts the court drew some conclusion. We're not talking about those conclusions in a particular set of facts. We are talking about the state of law, the view of law. The 2G judgment therefore opens up an important door for an Article 143 consideration. And I would very humbly submit, these doors probably will be kept more and more open as and when the president comes with issues of public importance. Come. Just 1 second, please. And also to answer an objection raised by Mr. Venugopal, that we are not referred to the judgment in the recital of the reference. He didn't argue. He didn't argue. Very. Because the 140 reference is a sui generis, and it is not akin to a pleading in a petition, writ petition or a suit. So what the president thinks is advisable for to seek a reference before the honorable court and seek his opinions on the questions referred to. There is no one particular form to be prescribed. You can't, probably the president's hands tied by forms and precedents. So it's only the ultimate test will be, will the court enter into answering a reference because of the importance of the questions raised? And if the field is, even if the field is occupied to some extent by some judgment, the court will enter into the reference and probably agree with any one of the judgments to occupy the field. That will be a later point of time.
I'll take only 10 minutes.
Attorney,
Your Worship, please.
3 questions. Apart from the various references that you have made, you will also have to sometime answer why 145(3), though you made a request, it was not accepted, that's a different matter. That will not give rise to a need to ask for an opinion on that, a view. Second is a larger question about 142. What's the need for it for an opinion on the scope of 142? Third, 131 also doesn't arise at all. Where should we answer 131? These 3 questions.
We will answer.
Keep it in mind. Whether we should get into those 3 questions, you will have to answer.
We will address your lordship on the importance of this question. You want to raise the importance of the question. Because the reference has been framed after a considerable application. So the importance of the questions are arising because what a particular judgment has done is the correct view of law. Therefore, we're on the correct view of law on particularly the scheme of Articles 200 and 201. Everything hinges along the 200 and 201 scheme. So probably we'll also, when we take into the question, you'll also probably persuade that as far as that's concerned.
Well, I'll just take 10 minutes on this. Lord, first of all, my lord, Article 143 my lord, needs two contingencies for the Honorable President to exist. A, the question of law has arisen, and B, a question of law is likely to arise. My lord, that is number one. And my lord, I'll read only few paragraphs from 2G judgment, my lords. The real, my lord, issue is, kindly see the importance and significance of this reference. My lord, there are in all 15 references made by the Honorable President to this court. My lord, all were with regard to a particular issue, whether the tribunal has the power, whether a particular bill is repugnant to the central legislation, etc., etc. This is for the first time where the Honorable President has felt that there is a functional disharmony which has arisen and which will arise because there has been no authoritative judicial pronouncement except, my lord, the judgment in question in case of Tamil Nadu, where one organ of the state fixes time schedule for the another organ of the state and also provides for the consequences of deemed assent. My lord, that is the reason why, my lord, this judgment, this reference itself is a sui generis reference where the Honorable President is pleased to request your lordships to advise her that there is a constitutional problem, a constitutional functional problem, how the President would act, how the governor of the state would act, what are the contours of Article 200, 201, and my lord, the President's power of assent under Article 111. Now, please see, my lord, in case of 2G, my lord, there are two distinct factors, and still the court has laid down the law that reference is maintainable. A, my lord, if your lordships can see, my lord, the question, your lordship did not read the question. The questions which were referred for your lordship's advisory jurisdiction, one of the question was whether judgment of two honorable judges reported in so-and-so lays down the correct law. It was a direct, my lord, as if it was an appeal. So the principal argument against the maintainability was with regard to whether this court would exercise one advisory jurisdiction virtually sitting in appeal because one of the questions was so framed. Lord, now in this context, Lord, please come to para 48.2, Lord, of the judgment in 2G. Lord, that is page 8181, volume 5.21, page 8181. 48.2, my lords. My lord, your lordships would kindly bear in mind, my lord, your lordships do not generally go into a judgment already decided, not as a jurisdictional issue, that 143 does not permit you to do that. It is a self-imposed restriction that while exercising advisory jurisdiction, we will not go into the question of whether one particular judgment is rightly decided or wrongly decided. But in 2G, my lord, your lordships have said that even that is permissible. Now, please come to page 48.1 and 48.2. 48.2, my lord. The second limitation, a self-imposed rule of judicial discipline. Your lordships have, my lord?
Yes.
The, my lord, it would be page
8181.
8181, my lords. The para 48.2, the second limitation, a self-imposed rule of judicial discipline, was that overruling the opinion of the court on a legal issue does not constitute sitting in appeal, but is done only in exceptional circumstances such as when the earlier decision is per incurium or delivered in absence of relevant or material facts, or if it is manifestly wrong and capable of causing public mischief. For this proposition, the court relied on the judgment in Bengal immunity case, whereas it was held that when Article 141 lays down that the law declared by this court shall be binding on all courts within the territory of India, please note this, my lords, it quite obviously refers to courts other than this court, and that the court would normally follow past precedents laid down in that judgment. In fact, overruling of a principle of law is not an outcome of appellate jurisdiction, but a consequence of its inherent power. Your lordships can say, if persuaded, that Tamil Nadu judgment is not laying down the correct law. It's not your lordship's appellate power, is your lordship's inherent jurisdiction, inherent power. This inherent power can be exercised as long as previous decree vis-a-vis in a list inter partes is not affected. It is the attempt to overrun the decision of a previous case that is problematic, which is why the court observed as under, my lord. Please now come to 45, para 45, lords, where the court distinguishes decision and the point of law decided in that decision. My lord, page 817, my lord, and 2 paras, my lord, I am done. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri.
Paragraph?
Para 45. 8179. And 2 very interesting paras, my lord, which generally go unnoticed, my lord, but I must place for your lordship's consideration. Para 45. My lord, dear argument was that one of the questions referred by the Honorable President is whether this judgment is right or wrong. Can you do that? In answer to that, my lord, this court, my lord, speaking in this reference judgment, says this, 45. The main emphasis of Mr. Sorabji was on the second part of para 85 of Kaveri 2, which according to him prohibits this court from overruling a view expressed by its previously under Article 143(1). We are not persuaded to agree with the learned senior counsel. The paragraph has to be read carefully. Now, please, the Justice Sawant first considers the case of a decision of this court, whereas in the subsequent sentence he considers a view of law expressed by the court and attempts to explain the difference between the approaches to these two situations. These words are sometimes used interchangeably, but not herein above. We believe that Justice Sawant consciously draw a difference between the two by using the word when further this court overrules the view of law after discussing the decision. Then 47. Therefore, the reference in para 85 of Kaveri to decision and view of law must be severed from each other. The learned judge observes that in case of a decision, the appellate structure is exhausted after the pronouncement of the Supreme Court. Therefore, the only option left to the parties is to review, etc. Now, please see Classet MD. However, this is important and I place respectful emphasis. However, what is not eternal and still malleable in the eyes of law is the opinion or view of law pronounced in the course of reaching the decision. Justice Sawant clarifies that unlike this court's appellate power, its power to overrule a previous precedent is an outcome of its inherent power when he says, that is again in a reference. Justice Sawant is deciding whether 143 would cover overruling a judgment and says, which is affirmed in 2G, that yes, we can overrule the question of law decided in the judgment. Lord, now kindly see 2 paragraphs and they are very interesting paragraphs. Para 61 and 62. Lord, because this, Lord, it appears that has been a consistent tendency of opposing reference of the Honorable President, and so far in our history of Lord, this constitutional democracy, there are only 15 references made by the Honorable President on individual bill or individual facts, etc. Please see 61. From the aforesaid, it is, your lordships have 8187. From the aforesaid, it is demonstrable that while entertaining the reference under Article 143(1), this court had analyzed the principles enunciated in the earlier judgment and also made certain modifications. The said modifications may be stated as one of the modes or methods of inclusion by way of modification without changing the ratio decidendi. For the purpose of validity of a reference, suffice it to say, dwelling upon an earlier judgment is permissible. That apart, one cannot be oblivious of the fact, etc. But see 62. It is of some interest to note that almost every reference filed under Article 143(1) has witnessed challenge as to its maintainability on one ground or the other, but all the same, references have been answered except in Muhammad Ismail Faruqi, that Babri Masjid case, which was returned unanswered, mainly on the ground that the reference did not serve a constitutional purpose. Basically, the court said, we are not experts on the subject of adjudication which the President has referred. Kindly, my lord, and your lordships are aware of the fact that the highest head of the executive is seeking your lordships' guidance that there are judgments of 5 judges, 2 judges, 3 judges, 7 judges, and it has created a constitutional functional problem for us. How would the President govern?
You can't expect the Supreme the conflict of judgments.
I'm not.
In an opinion.
Functionality, what would be
a larger bench.
what would be the contours of Article 200? Am I bound by the 3 months deadline? Am I bound to record reasons when the Constitution doesn't provide? Am I bound to intimate everybody? And is it permissible for the court to say that every state will come to the court? Lord, we are not, my lord, we will be addressing this on the merits of the case. But, my lord, there has to be a difference and deference when, my lord, the court is dealing with constitutional functionaries, which is a part of separation of powers. And therefore, my lord, one of the questions raised is, could the bench of the strength which decided the question without setting aside their judgment, my lord, your lordships, my lord, is requested to opine, have decided this question in light of the constitutional mandate under Article 145(3), and despite a request being made that please refer to the larger bench. This is one of the questions being answered. This, my lord, question is a sui generis question in itself, my lord, as compared to other questions. My lord, therefore, my lord, we'll address your lordships on merits, and my lord, we'll satisfy your lordships about the, we will assist the court, my lord. This is not a list to be decided.
Both
Yes.
sides probably are very clear that we are in advisory jurisdiction.
Yes.
We are not sitting here as appellate forum.
My lord, sir.
You are also saying, they are also
Yes, yes.
ending that. So it's very clear.
Yes.
You are absolutely right. 143(1), question of law has a reason or may arise in future. We will answer that.
Correct.
Whether a question of law first has a reason, and if a reason, how it is to answer, right?
What are the contours, etc.? Yes.
That process, the court can render an opinion that a judgment does not lay down the correct statement of law.
Your
Or
lordship.
judgment lay down a correct statement of law. But that will also not technically amount to overruling the judgment. It will be a different opinion. For overruling, you might be required to refer.
My lord, the 2G judgment, my lord, if I take your lordships.
Maybe
My lord, 2G judgment and my lord, in Kerala bill, I think 7 judgments of this court, my lord, has said that in a reference, answering the reference on a question of law, on a proposition of law, your lordships can even overrule the judgment.
I mean, that part can be checked. Otherwise,
Lord, para-
yes, we can always declare
My lord,
that.
para 56, my
Does
lord,
not lay down-
immediate, my lord, immediate, para 56 of 2G.
50.
Para 50 and 56. My lord, just to answer your lordship's question. Kindly, my lord, come to para 50 and 56. My lord.
Yes.
My lord, 8182. Para 50, my lord, 8182, your lordship said, my lord, which relies upon special courts bill. That's 7 judge, my lord, bench judgment.
Which volume is that?
Para 5, my lord, it starts with finally. I'm sorry, it is volume
50.
5.21, page 8182. directly answering, my lord, what my lords, my lord, were pleased to put to me. Does your lordships get, my lord?
Yes.
My lord, Justice Vikramnath gets 50. But this is 2G.
I can what it first, huh?
No, your lordships are always, my lord, more techno-savvy than the rest of us, my lords. Finally, a 7-judge bench of this court has clearly held that this court, under Article 143(1), does have the power to overrule a previous view delivered by it. Chief Justice Chandrachud in Special Courts Bill.
You can be overruled, but not a decision.
Correct.
That's right.
That's what,
But
clarify.
please read, my lord, what the 7 judges say. We are inclined to the view that though it is always open to the court to re-examine the question already decided by it and to overrule, if necessary, the view earlier taken by it, insofar as all other courts in the territory of India are concerned, they ought to be bound by the view expressed by this court, even in the exercise of its advisory jurisdiction under Article 143(1). Then, my lord, para 56, my lord, kindly have a look at para 8185, my lord, para 56.
one.
Even legislatively, if we overrule a judgment,
You can just say in case of saying this is the VP privileges case. Basically, it's overruled 6 judges in the exemption issue. That fundamental rights in action privileges.
I don't consider they are article. It's a wrong law.
My lord, I'm not reading it. My lord, Keshav Singh judgment, your lordships are aware, my lord, that Uttar Pradesh, the dispute between, my lord, the assembly and the, my lord, there was some privilege issue where, my lord, the reference was made. And in that, my lord, the honorable court overruled the view taken that this judgment does not lay down correct law. Well, otherwise, my lord,
Affirming or overruling a view definitely is permissible.
Certainly.
Otherwise, how will you exercise 143?
140.
Can't exercise that. That is understandable.
there's even the legislative process also.
But
An act cannot take away the mandamus, the chief was saying. Same independence of judiciary.
pardon.
No.
Oh, that's a separate. Yes, my lord, we will be. My lords have taken the view, my lords. My lords in that extension of.
Yes,
Certainly, my lord.
Justice Nath and
No, we are not, fortunately, my lord, faced with that situation. We are possibly, my lord, if I may say so, faced with a converse situation.
Just one submission for your lordship's kind consideration.
May I be heard?
Which is,
Only,
Which-
Mr. Salve wanted, my lord,
Yes.
5 minutes.
No, I want
Can I just-
5 minutes by the clock.
Just Mr. Kaul, let Mr. Kaul finish after finish.
my lords, 2G, as fell from my lords, emphasizes the distinction between decision and a view of law, and a review and a reference, and goes on to say that a review or a decision deals with the lis inter partes. A view of law is what is not eternal, malleable, and is subject to overruling, clarification, and modification. And that is why, my lords, in para 101 of the 7 judges' judgment, which is relied on in para 50 of the 2G judgment, they say we can overrule. And overrule, as felt from my lords, is not in exercise of either appellate jurisdiction or appellate jurisdiction being vested by a presidential reference, which can never be done. It is an exercise of the inherent power conferred on the Supreme Court to look into it and overrule it. And that is the reason why it was done, and 2G referred to it, refers to Kaveri. In fact, my lords, Kaveri, subject to correction, does not deal with the 7 judges' decision in the manner it ought to have, which is para 101, which talked about that 143(1), you can exercise the jurisdiction to overrule. And that ratio can be clarified So the fundamental error is to say that you're vesting an appellate jurisdiction in this court while exercising its jurisdiction, while answering an opinion asked for by the president. It is not an appellate jurisdiction that your lordships are exercising in the matter. And my lords, as far as a reference is concerned under 143, the president's opinion and satisfaction has not only been held to be non-justiciable, has been the final arbiter as far as the issue is concerned of whether a question arises. Is that question of such public importance that the opinion of the Supreme Court is needed on it? That is where, that is the decision. Then whether your lordship choose
That
to...
cannot be correct, Mr. Cole.
Yes.
143(1) talks of may, and
Yes.
that's why 143 to talk of shall.
Yes.
In shall, we are bound. We
Yes.
have to answer it because that will referable to 131. In 143(1), first we will determine that is there a constitutional question of law has arisen or is likely to arise which requires our opinion.
My lords, your lordships are
It's not something 143(1) that a reference comes and we are.
No, my lords, I didn't say that. My lords, I did not say that at all. Your lordships are absolutely right. All that I said for 143(1) was the satisfaction of the president. Whether your lordships answers it or not, because your lordships has laid down guidelines to say that it could be a case where your lordships feels it's purely political in nature, ought not to be answered. Or such questions of fact or expertise are involved, we can't answer that. But all that I'm saying is that satisfaction of the president sending it, whether your lordships answers it or not, is a separate issue.
Court is satisfied.
Yes, absolutely. That's all that I'm saying, Malas. There is no difference on that at all. But all that I'm saying is it cannot be treated today as if your lordships are deciding lis inter se. Your lordships will only be deciding pure questions and views of law, which your lordships in exercise of your lordships jurisdiction under 143 are fully entitled. I'm very grateful.
Happening for whom?
Malas, for the state of Madhya Pradesh. Very grateful.
Yes.
Malad, just 3 quick points, Malad. Your lordships have seen all the judgments. I don't propose to read any of them. Your lordships would have noticed this is not a jurisdictional bar. It is a self-imposed discipline. First of all, Malad, it's not a jurisdictional bar. The way, because we use the word maintainability rather loosely. Maintainability normally is a jurisdictional bar. Malad, the very doctrine of precedent is a self-imposed limitation. Let's keep certain first principles clearly in mind. Under Article 141, your lordship's judgment bind every court in India. They don't bind the Supreme Court. That's why your lordships have a right to overrule past precedents. These are all self-imposed limitations, and for very good reason. So, my lord, it's not a jurisdictional bar. And Dr. Singhvi threw in 3 different expressions. First, he said stare decisis. Stare decisis, my lord, has never stood in the way of a court considering and turning around an erroneous view. Res judicata is quite another matter. In the facts of a case, a decree will continue to bind until that decree is set aside in a manner known to law. And that principle is not being affected. So, my lord, all these notions, and the third is, my lord, what is really happening today, with great respect, is you're putting the cart, this challenge in this manner puts the cart before the horse. Your lordships are not even engaged with the questions. When your lordships engage with each of the questions, your lordships will then say, this is covered, this is not covered. For example, if we are right, that on some of the issues, this honorable court has, and it happens many times in constitutional issues, in some of the issues, this honorable court has spoken with different voices. In one context, the court has said something, in another context, the court has said something else. The judgments need to be read, they need to be reconciled. And at the end of the day, your lordship may answer this question saying, this is covered by the judgment and there's nothing more for us to say. But that's not maintainability. That is answering the question saying, this is answered in the light of the following judgment. So, my lord, I think your lordship should, without any more waste of time, my lord, engage with the questions and consider which of them your lordships want to answer and how your lordships want to answer.
You also contributed in that waste of time to some extent.
I'm sorry, my lord.
You also contributed in that waste of time.
Absolutely, my lord. All of us have generously contributed to this.
Not generously. Not as generously as Dr. Singhvi and.
Yes, I've been the most miserly in that. I have nothing more to add.
Yes, you.
Normally you don't require mic, but you can have it.
It is only an issue of overruling an earlier view, number one. Number two, or making it authoritative without any doubt. Two modes are constitutionally and legitimately provided. One, a reference by a bench of this honorable court to a larger bench to provide consistency and authority without any ambiguity, much less than conflict. Number two, if Lord exercise it appears that there is no consistency in the conflicting views, requiring reconciliation, clarification, or modification, it is entirely permissible for a second method for the Honorable President to resort to 143, and more so if it raises a ambiguity on the application of constitutional provision. Therefore, it is entirely maintained. Thank you. Grateful. You are beginning.
Yes, I propose to make some broad submissions. Philosophy,
Otherwise,
Attorney, your timelines appear to be far exceeding what is.
No, I don't think I will exceed the time.
No, have you seen the timeline?
Maybe we will be within the timeline.
You will have to revisit it because otherwise.
No.
We'll conclude ours internally within 4 days allotted.
Very comfortably.
You will have to revisit.
Very comfortable.
The timelines given to us are, I think they will spread over 2 weeks.
I will not breach the timeline.
We can always overrule this time schedule. And
Your Lordship,
on the lighter.
we have my written submission paper book. It's volume 1.2, the soft copies, but I also handed over a hard copy to Your Lordship. So you are starting with the main issue. There's 2-3 issues. Then I line it out. I have certain be better to give an overview. I give the history. We'll be arguing without history. We will give the history. Going this way. I'm not going to overthrow the board. You will not come later. Comes later, and we come later. Why they know? I suppose so. 1 hour 30. Your Lordship, please. I set out about broadly 5 propositions in the written submission. One, of course, relates to the maintainability. I don't propose to deal with that question.
That you already addressed.
That's right. But before I do that, the series of questions that have been framed and placed before your Lordship for consideration have a certain internal intrinsic connection. And we are looking at 2 important provisions of the Constitution, Articles 200 and 201, and which, in the company of other provisions of the Constitution, occupies a special scheme in the distribution of powers between the governor, the president, and the legislature. So it's like a fulcrum where the governor and the president plays an important role as guardians of the legislative integrity and constitutional integrity. And the legislative role assigned to the president and the governor is now being noticed, endorsed, and acknowledged by several divisions of the court. Of course, this legislative role is not equivalent to a plenary powers of a legislature, but decidedly the constitution makers could have thought, why we need Article 200 and 201 at all? If in democracy only the legislature has the final say, and why do you have any roadblocks? Why do you have somebody to be a supervisor, a night watchman? So if 200 and 201 continue part of the constitutional scheme, there has to be some important assigned to 200 and 201. If in the course for any political other expedient reasons, and an argument is canvassed before the court that please look at 200 and 201 in this particular way, because that's going to be democratic. So I suppose the court will look at the concept of democracy, keeping in mind the institutional relevance of Articles 200 and 201. So as we go further, we'll say that what the Tamil Nadu judgment has done, and in the context of other judgments, there are a number of judgments will look at Articles 200 and 201. How the scheme will work, and what will the governor do, what will the president do, how do we read and interpret Articles 200 and 201, so on and so forth. We will in due course of time take a lot of those judgments. But the debates on the discharge of functions between the governor, the president and the governor and the legislative wings of the state, this functional assignment, I think is something very important. But that's the running, the blood which infuses the life into Article 200 and 201. So whatever issue that may arise, in the discharge of functions in the Articles 200 and 201, in the course of exchange of views between the governor and the president on the legislative assemblies, and there are some issues, whatever the issues that may be, and if they need to be resolved, how will you resolve them? So we find in the Tamil Nadu judgment that the court says, we will resolve those issues. We will provide answers to all those issues. So in the end, what has really happened is, I'll also place your lordship in consideration, read the text of Articles 200 and 201 as they existed in the constitutional text, and read them now as has been done by the pen and paper in the Tamil Nadu judgment. You will find the court has entered into a legislative exercise and nothing but a simple legislative exercise. Therefore, whatever issue that arise between, if there is issues arise between the governor, the president, and the legislature, then the parliament will certainly look into it. You have to address the parliament to say, look at the importance of the issues. The governor and the president cannot probably abdicate their highest responsibilities in ensuring that legislative compliance, the constitutional compliance of a law is ensured. Therefore, that's how I think the court would have probably looked at. As I said, the series of judgments where 200 and 201 have been dealt with by the court. 7 judges, 5 judges, 3 judges, etc. They all kept it in mind. That issue has all been kept in mind. Therefore, the court will probably, in my understanding, will reach several principles in delineating the scheme of Articles 200 and 201, keeping in mind the basic structure of the Constitution. To say the basic structure is only informed by a democratic principle which is confined to the legislature, I don't think that will be the more advisable way of looking at the basic structure doctrine. Therefore, 200 and 201, I say, is also a part of the basic structure, where the president and the governor occupy an important functional role in ensuring that if there is a non-constitutional compliance with a bill, the president and the governor will say stop. To do that stopping, I think if you call it, give some other name and then say, let me dilute the level of responsibilities of the governor and the president. That's where the Tamil Nadu judgment has ended. We'll place more submissions when you come to the question. So the questions that have been framed have been kept into mind. The series of judgments that have dealt with Articles 200 and 201. And that's why you lordship asked me a question about why are you talking about 145.3? Why are you talking about this particular question, etc.? I'll presently come to that. So in the tune with the range of opinions in Article 143, I say it's open to the Supreme Court while answering a reference to look into and consider any of his previous judgments and to find out the answer, we were trying to canvass that what is the correct state of law in Articles 200 and 201, which the President is concerned. The Tamil Nadu judgment, in deviation and departure from many other judgments, says if there is a dispute regarding, I'll presently play the paragraph of the judgment, if the dispute regarding whether the governor could reserve a bill to the consideration of the President, and the President has any issues on that, it should be as a matter of prudence, the President should come to the Supreme Court and seek his opinion. So it becomes a mandate for the President to always seek an opinion from under 143 whenever there's a doubt about whether the governor has actually given a consent, assent could be given or not, materials are available or not. So we enter into wide conundrum of issues in this case. So that is why it was found expedient to have this reference made before your lordships. Now, in my written submissions, let me invite your lordships, volume 1.2, page 410. Proposition number 1 relates to what we have already advanced. When you get to proposition number 2, also in a way deals with that question, but I would like to read that, page 411. So it is related to maintainability, etc. Then proposition number 3, your lordship.
I do not know. On 1 and 2, I have so much justification of I won't permit me to. That's not the job.
Then proposition number 3 at page 411, the doctrine of separation of powers injuncts the court from doing what the legislature alone can do. It's well known, it's part of our jurisprudence. The principle that the court declares the law by interpretation cannot be extended to essential lawmaking. As will be submitted below, the Tamil Nadu judgment has substantially rewritten Articles 200 and 201 of the Constitution, whether affecting such textual amendments of the Constitution will not be in opposition to the separation of powers principle is a matter of great public importance and for constitutional integrity.
Your written note.
Hey, written submission.
Submit today.
It's volume 1. I'm so sorry.
Yes.
You can just formulate your points because this in any case will be reading through.
Yeah, these are 5 propositions to begin with, to open the debate.
So one of the main proposition appears to be this court has encroached upon the legislative powers of the parliament or has sought to rewrite the constitution.
Right.
Or amended the constitution.
Yes.
Which is not permissible for this court. That appears to be your main submission.
That's one important submission. So how the judgment now, as I said, Article 200 before and after the judgment. So if you look at it, it will be it's so plainly visible that it is a matter of textual amendment of the Constitution. So we'll presently come to Article 145 to 3 argument. So even in the guise of interpretation, laying down guidelines, Vishaka, etc., so can the court go to the extent of saying that I will myself, as I say, take a pen and paper and rewrite the Constitution? And at page 414, proposition, I'm skipping proposition number 4, this There was in the Kerala a written submission that an objection Mr. Venugopal did not press. There was an objection that the presidential reference does not advert to the Tamil Nadu judgment, and there's something like you're suppressing a judgment from the court. And since that has not been addressed, wisely so, I don't propose to go into proposition number 4. But I understand that Article 143, as I said earlier, is not does not admit of questions such as pleading, etc. Now, proposition number 5 at page 414, and that's also been addressed earlier when what we are actually seeking this court to do under Article 143, that the state of law or the view of law, etc. If your lords will permit me to straight away to in this written submissions is in 4 parts at page 415. Page 415. Part 1 deals with the special features of Article 143. I'll keep coming back to it as and when necessary. I don't propose to read it because you understood that there is a significant difference between 143 and other jurisdictions of the court. And what will be ordinarily attributable to jurisdiction, the exercise of jurisdiction, etc., does not relate to Article 143. Then these part 2 deals with the presidential reference maintainable. We've asked this question. Then part 3, the text of the constitutional post Tamil Nadu judgment. If your lordship permit me to read that, before that, may I address your lordships on the question posed to me about 145.3. Situation. 1461. Question number 12, at page 461. Will not kindly turn to page 61 of this volume. 61. 461.
61. From 416 we go to 461. That's part 4.
Because what we have, that's right, part 4. So what we have done is, with reference to each one of the questions, we'll be having a division of labor, and few questions will be certainly answered by me, and others will be dealt with and solicitor. So since part 4 is about question number, I begin with question number 12.
Yes.
This is how the question reads. In view of the proviso to Article 145.3, is it mandatory for any bench of the Supreme Court to first decide whether the matter involves a substantial question of constitutional interpretation and refer it to a bench of at least 5 judges? If the text of Article 145.3, says rule. 145.1 reads like.
If your contention that in every matter, the court should first go into the question as to whether it is mandatory to refer to the if a bail matter comes, they will first decide as to whether it has to be referred to.
No, that's not going to be our submission. It's constitutional
The
interpretation.
question should have been involving an interpretation, involving any of the articles of the Constitution.
Yours kindly read 143 for a minute.
No,
The
the
minimum
question is
number
in
of
view of the
judges-
proviso to Article 145(3).
The minimum.
Mandatory
number-
for any bench of the Supreme Court to first decide whether the matter involves a substantial question of constitutional interpretation and refer it to bench of at least 5 days. If you go through this exercise on Mondays and Fridays, we'll have to sit
No, no.
till 12 o'clock in the night.
Your lordships have answered, dealt with this in various judgments.
They can-
So whether it will be
they can-
reduced to that minimum, whether it will be reduced to that minimum or it stands at a higher level. Therefore, at one level, one may say every question that comes to the Honorable Court will may involve interpretation of a provision of a constitution, application of a provision of a constitution. We're not saying that.
Which involve interpretation should go to.
One 145(3) is very clear in its prescription. There's a minimum number of judges who are to sit for the purpose of deciding.
But what is this? Whenever
Involving
any question involving an interpretation of the provisions of the
a
Constitution.
substantial question of law as to the interpretation of the Constitution. Your lordships have on many occasions dealt with this provision and have given certain opinions on how do we deal with them. I look at them.
It's a broad contour. It is not a mandatory or anything. It shall be by 5. That doesn't mean that mandatorily every time the court, the moment a constitutional issue is raised, we will have to refer it. But in any event, why should we answer this question at all?
Let me tell you why you're asking this question. Before the Tamil Nadu bench and even before the Punjab was, it was sought to be persevered for the court that here you have a bench of 5 or 7 judges who looked at Article 200 and 201. And if you have to disagree with them, then ordinarily the practice of the court is that you refer it to a larger bench and goes to a bench of 5 or 7 judges, the case may be. So we have those cases even in Inamdar and Islamia. So a larger bench is now sought to be explained by a bench of 5 or 7 judges. Even when explanation takes place, you have a bench of not a bench of 2 judges.
The judgment of 9 judges is explained by 7.
Yeah. Let me try to open whatever here. So we are trying to point out that if there is an interpretation of such constitutional importance, which is not a mere daily appearance of matters in the court where 14 and 21 are involved. We're not talking about those categories of cases. So in those categories of cases where matters of constitutional importance for the working of the Constitution, working of the institutions of the Constitution, under the Constitution, the integrity of the Constitution, so on and so forth. Certainly, 145(3) imposes a mandate. This mandate can be certainly exercised after the court goes through a particular judgment and whether there is a need for referring it or not. That will be an exercise at a different level. But if the court were to say that notwithstanding issues of constitutional interpretation, which are of such public importance, and notwithstanding the fact there are larger bench views on this question, then a lesser number of 2 judges can decide it and answer it, I think is directly in conflict with 145(3). The court exercises both original and appellate jurisdiction. Cases come from various high courts on the interpretation or the application of state legislation, central legislations, regulations, rules, orders, so on and so forth. And therefore, in that context, when the court finds that important questions of substantial questions of the interpretation of the Constitution involved, If the matter can be disposed of on a lesser level, on a facts, etc., then certainly 145(3) may not arise. But if I take interpret the provision of a constitution, which will have implications, as I said, for the functioning under the constitution of the institutions of the constitution. So therefore, the daily stuff where this court deals with the application of 14 or 21 will be a different canvas altogether. We are talking those very special class of cases. And articles 200, 200 fall into those very special class of cases.
What's your proposition that the moment a question of law relating to interpretation of the constitution is raised in a ground in an SLP or submitted, every such matter has to be referred to a CD?
The court will address, is the field already occupied by any conclusive authority? I'll presently praise those decisions where these have come up for consideration. The court will address that question. If there is a conclusive authority or authoritative opinion, 2G talks about authoritative opinion. So it is not any opinion. That's for a conclusive authority or authoritative opinion. Is there such a conclusive authority? The court will address that question first. If there is no conclusive authority, but while even looking at the conclusiveness of the authority, the court finds there are conflict of views, 2, 3, 5, etc. Therefore, then the court will certainly say, if this is a matter of such public importance, constitutional interpretation, I think I am duty bound to refer to a constitutional bench. It's a high responsibility. The court interprets the constitution, substantial questions. So it's a high responsibility. Therefore, when the court enters, the moment the court enters into a disagreement on a field which is either occupied by a number of judgments, 5, 7, 2, etc. Should the court say, no, I will probably take the mandate on myself and let me bear the mantle to answer a question? The court will be very slow. My submission, the court will be very slow before it finally takes a view that I need not refer the matter to a larger bench.
And even you should not ask that in an advisory jurisdiction.
No,
you should aim for a determination in a regular.
No, why
that will be binding on other benches, saying that we have to do it. But then you are asking as a question, as an opinion. Opinions also could be polyvocal.
Let me try to proceed further, and the Lordship probably heard why this question is being asked. Firstly, the question being asked because we have the instance of a Tamil Nadu judgment where, in breach of 145(3), the court has proceeded to answer some of the questions. So it becomes important for the president to understand and for the government also to know in what circumstances a 145(3) can be kept aside or maybe ignored, disregarded, and departed from. Therefore, this question has been asked. It's important for every functionary, government, legislatures to know whether 145(3) is important or not. Is it mandatory or not?
Yes, Mr. Attorney, please.
I was reading at 461, paragraph 43. Lordships may permit me to refer to Balasaheb Patil and what this court had said in that.
Karnataka.
In any case, we feel there is a requirement to provide a preliminary analysis with respect to the interpretation of this provision. In this context, we need to keep in mind two important phrases occurring in Article 145(3) of the Constitution, which are substantial questions of law and interpretation of the Constitution. By reading of the aforesaid provisions, two conditions can be culled out before a reference is made. The court is satisfied that the case involves substantial question of law to the interpretation of the Constitution, the determination of which is necessary for the disposal of this case. So that's the second stage. If you don't pass the second stage, then there is a breach of 145(3). Then next paragraph. Any question of law of general importance arising incidentally or any ancillary question of law having no significance to the final outcome cannot be considered as a substantial question of law. The existence of substantial question of law does not weigh on the stakes involved in the case. Rather, it depends on the impact of the question of law will have on the final determination. If the questions having a determining effect on the final outcome have already been decided by a conclusive authority, mark this word, conclusive authority, then such questions cannot be called as substantial questions of law. I mean, stopping it for a minute. If such a question has been decided by several conclusive authorities, bench of 5, 3 or 2, then would it not be, I think, prudent for the court hearing a matter involving the same question to say if there are the larger benches and if that's a conclusive authority, or if I doubt even about that conclusive authority, then I need a conclusive authority. The court needs to present a conclusive authority in order that the questions are not repeatedly brought before the court. So you need to answer them by way of a conclusion so that the jurisprudence is settled and the authorities and Article 141, precedent, etc., all that will take their effect. Therefore, let me read further. In any case, no substantial question of law exists in the present matter, which needs reference to a large event, the cardinal need to achieve a judicial balance, etc. Then, next paragraph. Furthermore, this court in K.S. Puttaswamy has noted that when a substantial question as to the interpretation of the Constitution arises, it is this court and this court alone under Article 145(3) that is to decide what is the interpretation of the Constitution shall be. And for this purpose, the Constitution enters its charge the minimum of 5 judges of the court. Reference can be usefully made on the following judgments, and so on. So, on the question of the interpretation of Article 200 and 201, I just give a CA to those judgments so that why we're talking about it. The following judgments are stated the law as follows. When in Samsher, this court has recognized that the governor is required to exercise his discretion while discharging certain constitutional functions, including inter alia, those envisaged under Article 356 and 200 of the Constitution. Then, next page, in Valluri Basavaya Chowdhury, the court held that save in the case of a money bill, the governor retained the discretion to withhold assent to a bill presented before him. In Ramesha Prasad, this court observed that the governor discharges the dual responsibility, being accountable to both the union and to the state in the exercise of its constitutional functions. In Navem Revia, this court recognized that the governor is vested with discretion in the exercise of powers under Article 200 of the Constitution. In B.K. Pavitra, this court held that the Constitution confers a discretion upon the governor with respect to the reservation of bills for the consideration of the President. It is observed that the discretion is vested in the governor to adopt one of the course of action set out in the substantive part of Article 200. The court further affirmed that the governor is entrusted with authority to reserve a bill presented for his assent for the consideration of the President, and such reservation may validly be exercised even contrary to the aid and advice tendered by the Council of Ministers. The Tamil Nadu judgment proceeds to say the governor in all his functions under 200 is to be is to go by the aid and advice of the Council of Ministers, is bound by the aid and advice of the Council of Ministers. I ask myself the question, if a bill presented to the governor is not constitutionally compliant, or what he thinks is not constitutionally compliant, am I required to go seek the aid and advice of the Council of Ministers, except by way of a consultation? These are all informal things, but to say that I'm bound by an advice, if the law is already unconstitutional, not constitutionally compliant. So where is the question of saying for giving my assent and withholding assent, I should seek the aid and advice of the Council of Ministers? Therefore, that's how in Pavitra, the court, it's a balance. It will be brought on record, paragraph 46 later, that in the light of the views expressed by the benches of the Honorable Court of varying strict on the scheme of Articles 200 and 201, it was requested before the bench hearing the case in Tamil Nadu Supra, the proper that the matter may be referred to a larger bench as mandated by Article 145(3). This submission is recorded in so and so. As to harmonize a little later, the submissions also advanced in the course of making oral submissions. However, the Honorable Court proceeded to render a judgment adopting the course of explaining and distinguishing the judgments in question. It is submitted that in such matters of constitutional interpretation, even the exercise of explaining or distinguishing should be undertaken by a larger bench. I think that will be the real essence of 145.3, because the matters of the moment come before the court. So we won't explain, but the larger benches will be explained. Put it on the proper that I follow a 145.3 route, having regard to the significance of what the court proposes to do and the impact on, I said, constitutional function. Next paragraph. It is further submitted that the breach of this mandate is akin to the act of court principle, namely, that an act of court will do no wrong. In other words, the act of court principle will include violation of principles of natural justice, not acting in conformity with mandatory statutory provision, as in the case of A.R. Antule, and in all those situations, and more importantly, in the context of a constitutional mandate, such as Article 145.3, a judgment so rendered cannot be said to express the correct state of law and shall be open to correction. That's why we talk about conclusive authority. The correct state of law will follow if there's a conclusive authority. Next, it is submitted that in the breach of Article 145.3, in the manner it has occurred in the Tamil Nadu judgment, is a matter of constitutional concern. Given various issues in the reopening of such a judgment, through the process of review, etc., it has become important to raise this concern, and such a concern deserves utmost consideration by the Honorable Court. There can be no two views on the question that in the absence of an authoritative pronouncement, paragraph 63 of the Natural Resources Allocation Judgment, or a conclusive authority on the subject in question, Srimad Balasaheb Patel, it will not only be prudent, but also proper for the court to go through the mandate of Article 145.3.
Yes. What is the next now?
Where is this? 200 and 201, where I will place it, before and after. Okay.
What is that?
451. Pages in 451 to 456. There are certain submissions. Before I read them, kindly turn to page 456.
Next of 201 and 21.
456 within that sub
So you want to,
Article 200, within the box you'll find Article.
As it stood before and as it should be read now.
As it stood before is what I'm going to read now.
as it's
Later,
before and
yeah.
how it has been read by the court.
We have picked
Now, how
up, that's right. We have picked up whatever the court has said about 200 and then added them as part of the way you read 200 now after the judgment. If there is any error in that, of course, you're open to correction. Now let's read Article 200 as it stood before. When a bill has been passed by the Legislative
Your
Assembly
question
of
number?
the state,
Question is.
456.
Your
Your Lordship, please.
This is a part of your written submission, or written submission to a particular question.
No.
You have divided your questions amongst yourself.
I know, I have dealt with 145.
Part of the question.
I'm now dealing with 200 and 201. How? That's right. how under the guise of interpretation.
This is independent of the question.
Learned Attorney General Melody is addressing your lordships as the learned Attorney General. I'll be assisting your lordships for
As a Constitutional for Union of India.
for the Union of India. We have different nuances. We
You know, because that, in the beginning, the learned attorney stated that we have divided,
Some questions, yes.
yeah, we are,
Yes.
we have,
There'll be no overlapping, but
Yes.
Of course, the
There'll be
bound to
no
be,
duplication
bound to be
of-
some submissions which may have some element of overlapping that cannot be avoided in a matter like this. So it's important for us to read Article 200 as it's the text of the Constitution. So when a bill has been passed by the Legislative Assembly of a state, or in the case of a state having a legislative council, has been passed by both the House of the Legislature of the state, it shall be presented to the governor, and the governor shall declare either that he assents to the bill, Lord Narasimha, got that page?
456.
I thought just Narasimha. Either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president, provided that the governor may, as soon as possible, after the presentation to him of the bill for assent, return the bill if it is not a money bill, together with a message requesting that the House or Houses will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message. And when a bill is so returned, the House or Houses shall reconsider the bill accordingly, and the bill is passed again by the House or Houses, with or without amendment, and presented to the governor for assent. The governor shall not withhold assent therefrom. I'll make my little comment on this little later. Provided further that the governor shall not assent to, but shall reserve for the consideration of the president any bill which, in the opinion of the governor, would, if become law, so derogates from the powers of the High Court as to endanger the position with the court is with Constitution designed to fill. Now, next page, we turn to how it now looks after the judgment. The portions marked red are introductions by the court. When a bill has been passed by the Legislative Assembly of a state, or in the case of so-and-so, etc., the governor shall forthwith, and in any event not later than a month from when it is presented, either on the aid and advice of the Council of Ministers or otherwise, on ground that a bill is of a description as provided in the second proviso here and below, or that a bill is of a nature covered by Article so-and-so, etc., where the assent of the President is a condition precedent before the bill can take effect as law, or on the ground that a bill is of a nature that, if allowed to take effect, then undermine the Constitution by placing the fundamental principle of representative democracy in peril within a period of 3 months from the presentation of the bill, declare either that he assent to the bill or that, if it's not a money bill, regardless of whether it is introduced in terms of Article 207, he withholds assent therefrom, or that he reserves the bill for the consideration of the President. Substantial insertion in the text of the Constitution. Provided that the governor may, as soon as possible after the presentation to him of the bill for assent, if he withholds assent, contrary to the aid and advice of the Council of Ministers, on grounds that the bill is of a nature that, if allowed to take effect, it would undermine the Constitution by placing the fundamental principles of a representative democracy in peril, then return the bill if it's not a money bill, etc. And little later it says, the House or Houses shall have the option to reconsider the bill accordingly. And if it is so reconsidered, the bill is passed again by the House or Houses without the amendment presented to the governor for assent, the governor shall not withhold assent therefrom. So you see a scene entirely different from what the Constitution makers envisage, to ensure that there is a fine balance between what the governor will do or the President will do, and when a bill which is of non-constitutional compliance is brought to his notice. So I will certainly look into certain other questions about whether the aid and advice of the Council of Ministers will bind when the bill is so unconstitutional. And then if the governor is to go and seek his advice and say, should I abide by your wisdom? The court says, yes, you are bound by the aid and advice of the Council of Ministers, and because you have no discretion. So all that flows by reason of the textual amendment of Article 200. Now kindly turn further at page 458. Provided further that in the first instance itself, and not in a situation where a bill is presented to the governor, again under the above proviso, the governor shall not assent to, etc. That's how it goes. We introduce this. That's a third thing now. Provided further, where the governor proposes to declare the bill is reserved for the consideration of the president, and whereas a declaration is contrary to the aid and advice received from the council of ministers on any other grounds set out in the first proviso above, such declaration ought to be made not later than 3 months from when the bill is presented, except when such presentation is in accordance with the first proviso above. Now, how do I understand the way the court has construed Article 200 and say, I read all of them into 200? Now, the governor will have to now follow this mandate, I think. The governor will receive the advice from within the scope of all these insertions, the textual amendments, the judgment has affected. See further, therefore, again, Article 201. 201 is a very simple provision. Bills reserved for consideration.
What is the last proviso?
You know, it's all part, I picked up from the judgment and added them here.
According to the last proviso is also added in the judgment.
Added, yes. And when I say it's added,
So
this is how the governor will be bound by it.
So the third proviso.
The governor will look at it, the president will look at it. Am I to follow this procedure? Therefore, it gets impregnated into Article 200. Can the governor say so? I will not look at all because only a judgment. He cannot say so. 201. When a bill is reserved by the governor for the consideration of the president shall declare either that he assent to the bill or that he withhold the assent therefrom. Provided that a bill is not a money bill, the president may direct the governor to return the bill to the house, or as the case may be, the houses of the legislature of the state, together with such a message as is mentioned in the first proviso to Article 200. And when a bill is so returned, the house or houses shall reconsider it accordingly within a period of 6 months from the date of receipt of such message, and is again passed by the house or houses with or without amendment, it shall be presented again to the president for his consideration. Now, the elegance and the simplicity in Article 201. Now, see after the judgment. When a bill is reserved by the governor for the consideration of the president shall forthwith, and in any event not later than 3 months from when the reference is received, which time may be exceeded for reasons to be recorded in writing, declare either that he assents to the bill or that he withholds assent therefrom, recording reasons therefore, and communicating such reasons to the house or houses of the state in terms of the proviso below. Provided that the assent is withheld, where the bill is not a money bill, the president shall direct the governor to return the bill to the house, or the case may be, the house of the legislature of the state together with such message, as is mentioned in the first proviso to Article 200, which message shall include the reasons specified in this article. And when a bill is so returned, the house or houses shall reconsider accordingly within a period of 6 months from the date of receipt of the message. And is again passed with the house or house with or without amendment, it shall be presented again to the president for consideration, who shall ordinarily not refuse assent thereto. You bind the hands of the president here. The Article 201 set does not talk about binding the president, giving or not withholding an assent. It's all certainly the president will exercise the highest level of consideration of a bill. If assent is withheld, she or he will withhold the assent. Provided all this further. Provided further that the president shall not use the above mechanism of withholding assent and sending a message to the state legislature more than once in the ordinary course of action. I thought the court has probably entered into a regulation-making power here. Provided further that when a bill is presented again to the president for his consideration, the president shall withhold assent again, record clear and sufficiently detailed reason therefor. We are looking at the president as an ordinary statutory authority. The recording of reasons I'll come to a little later, while it may be important for the legislature and the transaction of understanding between the governor, the president, and the parliament, the legislature is important. I'm not downsizing, it's important. But to say that you will do this, then further, another proviso, provided further that where the bill is reserved on grounds in Article 254(2), the decision shall be made on the understanding that mere non-conformity of the state bill with the union's policy ought not to be a ground for withholding assent. where do we get a question of union's policy here? See, if a parliament is enact a law, and if the executive policy, and executive policy, you lot know Ramdev Kapoor, executive decision can be taken even in the absence of a parliamentary legislation. See, if there is an important executive policy on health, any number of issues, health, education, we govern our country by many executive policies. So if they have important consideration for the entire nation, the president will be told, don't look into executive policies, whether they are in the state of a law or not, regulation or not. So provided so and so, that mere non-conformity ought not to be a ground for withholding assents. Provided further, that where the bill is reserved on grounds of patent unconstitutionality, the president may refer the bill to the Supreme Court for his opinion in Article 143. I mean, that's a fourth mandate that the president, whenever there is a bill where the governor reserves for consideration to the president, and the president finds it unconstitutional, the president is now asked to come to the Supreme Court. Invariably, if there is now look at the number of legislation where the situation will arise. We have an opposition to 140, the reference here today. I suppose every case of 140 will be opposed. Therefore, to us, it will be sent to the Supreme Court for his opinion under Article 143. So the president is virtually, the governor is virtually robbed of their highest levels of application of mind. When they commit a wrong, you can always find fault with that. But to say, I'll take away your discretion, your authority, your power. And therefore, you come to the Supreme Court every time there is a bill which the president thinks unconstitutional. I think this court will have more business than probably what it will otherwise have. Next, provided further that where a bill has been reserved on grounds of patent unconstitutionality, and the terms of reference from the governor involves purely legal issues, the president shall refer the bill to the Supreme Court's opinion in Article 143. Then, provided further that as and when the Supreme Court entered a decision, the president shall be bound thereby and shall not withhold assent from the bill contrary to the opinion of the Supreme Court, except where such bill has been reserved for considering legal as well as political issues, and such reasons for differing from the opinion of the Supreme Court is recorded in writing. Provided further that where no reasons are recorded at any stage, where reasons that are required to be recorded, the court may presume the lack of bona fide in the action of the union of the president. Where I come under 143, under 143, the court will say whether the lack of bona fides. So I think it's again rewriting 143 itself. Provided further, the matter of prudence, states ought to enter upon pre-legislation consultation with the union when proposing to introduce a legislation on any matter which may or ought to be reserved for consideration by the president. That's a matter for political institutional arrangement. We have the council of,
Mr. Sibal and Mr. Mehta have not been in a position to agree on a piece of land in Bangalore. In spite of so many suggestions given by the court.
Left to us, we will immediately agree. Our clients are unable to.
Provided further that a challenge to the decision of the president in withholding assent shall be challenged only by the respective state governments and only before the Supreme Court. I've not left out anything. I've been carefully trying to see that whatever the court has said.
Whether the learned attorney would be concluding today.
Your Lordship,
would he be concluding today?
Yeah, most probably. I think I've only two more issues. The rest will be handled by the learned solicitor.
Mr. Chairman.
Lordship, please. I was at page 560. Just for Lordship's convenience, we have this relevant paragraphs of the judgment from where we have tried to say how.
Well, according to you, the Constitution is amended.
Your Lordship, please. Just for Lordship's convenience, so that you know where we had, the red mark portion we say are the insertions in 200 and 201. We have picked it up from various paragraphs of the Tamil Nadu judgment. The reference to the respective paragraphs are given in the footnote.
All discussion about what is in the conclusion.
Your Lordship, please.
No, this you have culled out from various paragraphs of the judgment, like.
That's how it is engrafted into articles 200 and 201.
But then what does this is? There must be some final conclusions in the judgment.
Now I'll read that. I'll come to it. So before I read the final conclusion, there are a few more paragraphs I just wanted to read. I'll read that. I thought this for your Lordship, and for that we know where we have picked up this, where we have picked up from. We'll now kindly turn to page 465 of my submission. I'll quickly run through about 3 or 4 issues. I wish to confine to these 3 or 4 issues because they are connected to the way 200 and 201 now undergone a change. Page 465 is issue number 1. And you'll also see issue number 1 at page 465. And issue number 2 at page 469 have an intrinsic connection. I'll just quickly take your Lordships to what I think should be the proper way of looking at 200 and then connect it to question number 2. May request your Lordship to keep the Constitution by Act Article 200 and 201. Let me address one broad question, tracing the history of Article 200 from Government of India Act 1935 and thereafter during the Constitutional Assembly debates, etc. The court comes to a conclusion that the word discretion has been dropped in the Article 200 as it now stands. Therefore, the governor does not have the discretion to deal with a bill. He must act by the aid and with the Council of Ministers. So that's, I just want to say, what are the options available to the governor and how the discretion part of it, if it is taken away. It's not discretion in the sense somebody exercise among various courses of action, like a statutory authority we're talking about. So word discretion, even though it does not find a place in Article 200, it'll have an implication as to how you read Article 200, even if it is there, if it's not there. I just kindly turn to page 466. Article 200 interest, 466. Article 200 entrusts the governor with discretion when he receives a bill the governor is constitutionally mandated to adopt from a quartet of options or a synthesis of options contained therein. The governor shall declare either that he assents to the bill, or that he withholds assent therefrom, or that he reserves the bill for the consideration of the president, or he may return the bill. It's important to note that the written submissions filed by some states, including states of Kerala, Himachal Pradesh, and Meghalaya, or in concurrence with the above state 4 options, are available to the governor under Article 200, as said above. This stand is at variance with the Tamil Nadu judgment, which only talks about 3 options. Submitted, the said stand reinforces the need for asking question number 1 of the reference. There is a difference of views even on this question. Now, Article 200 cannot be read to bind the governor to the aid and advice of the Council of Ministers. If so, the independent authority with the governor may become odious. The Constitution provides the discretion to the governor. We have to use this word for some reason or the other. So provides a discretion to the governor to follow one of the more course of action enunciated in part of Article 200. And as enumerated in B.K. Pavitra, is immaterial that the word discretion does not figure in the article or it has been dropped. The judgment, there's a lot of emphasis on this question. I don't want to go in greater detail. So the governor can, how I read the proviso on 200, I just quickly go through it. Paragraph 52. The governor can reserve a bill in the case of eventuality of a repugnancy with a concurrent list specified in Article 254(2), or when as mandated by Article 200, second proviso relating to the bill affecting the powers of the High Court, or when there is a legitimate doubt about the validity of the law. The ambit and power entrusted to the governor under Article 200 to reserve a bill for the consideration of the President is not restricted to one eventuality of Article 254(2) or 2 bills falling within the second proviso to Article 200. The first proviso, therefore, deals with the situation when the governor is bound to give his assent. The second proviso makes reservation compulsory where the bill would become law. Derogate from the powers of the High Court, but reservation is important note, should be made without the governor himself giving assent to the bill. The article does not contemplate the governor giving his assent and thereafter, when the bill becomes a full-fledged law, reserving it for the consideration of the president. Indeed, the governor is prohibited from giving his assent where such a reservation by him is made compulsory. The Constitution would thus seem to contemplate only bills passed by the House or House of Legislature being reserved for the consideration of the president and not laws to which the governor has already given his assent. That's what Kameshwar Singh talks about. Now, in Pavitra, what this court said is like this. It would not be possible for this court to reflect upon the situation in which the power under Article 200 can be exercised. The court is held as follows. Framers carefully issue defining the circumstances in which the governor may reserve a bill for the consideration of the president. By its very nature, the conferment of the power cannot be confined to specific categories. Exigencies may arise in the working of the Constitution which justify a recourse to the power of reserving a bill for the consideration of the president. They cannot be foreseen with the vision of a soothsayer. The power having conferred upon a constitutional functionary, it is conditioned by the expectation that it will be exercised upon a careful reflection and for resolving legitimate concerns in regard to the validity of the legislation. Now, there is a slight deviation from what this court does from B.K. Pavitra that will be pointed out a little later. This court cited and placed reliance on the following paragraphs and from Hoysh in paragraph 8 to 6. There may also be a bill passed by the state legislature where there may be a genuine doubt about the applicability of the provisions of the Constitution, which require the assent of the president to be given in order that it will be effective as an act. It is for the governor to exercise his discretion to decide whether he should assent to the bill or should reserve it for consideration of the president to avoid any further complication. Even if it ultimately turns out that there is no necessity for the governor to reserve the bill for the consideration of the president, still having done so and obtained the assent of the president, the act so passed cannot be held to be unconstitutional on the ground of want of proper assent. This aspect of the matter, as the law now stands, is not open to scrutiny by the courts. But precisely what has happened here. In the instant case, the finance bill, which ultimately became the act in question, was a consolidating act relating to different subjects. And perhaps the governor felt it is necessary to reserve it for the assent of the president. We know hesitation holding that the assent of the president is not justiciable and cannot spell out any infirmity arising out of his decision to give such an assent. Now, this by conclusion on question number 1 is submitted that in a proper reading of Article 200, the 4-option theory is the correct theory. Question number 1 is based on the need for the view on the correct theory. The report of the Sarkaria Commission on Center-State Relationships in paragraph 5.1.02 is also an endorsement of this view. Paragraph 4.5.01 of Justice M. Pucci Commission report on the evolution of center-state relations in India also endorses the 4-option theory. That closes my brief submissions on issue number 1. Would you now kindly turn to page 469? Because the conclusion drawn here is that the governor will be bound by the aid and advice of the Council of Ministers. How do you really look at it? So that the question is properly framed. Is the governor bound by the aid and advice of the Council of Ministers, tendered by the Council of Ministers, while exercising all the options available with him when a bill is presented before him under Article 200? So if the 4-option theory is endorsed by 2 reports and the 4-option theory is probably the correct theory, and then in that context, am I expected to abide by the aid and advice of the Council of Ministers? To be told Assent, I mean, apart from a consultation at highest level, do we have to abide by the Council of Ministers' advice? Therefore, it is actually subverts my options available under the 4-option theory. So then kindly turn to page 469. Article 163 is an illustration of the Council of Ministers principle in the states. It provides, there shall be a Council of Ministers with the Chief Minister at the head to aid and advise the governor in the exercise of his functions, except insofar he is by under the Constitution required to exercise function, or any of them in his discretion. Clause 2 makes the governor's decision final on whether a matter is discretionary, and Clause 3 bars any court from inquiring into what advice was tendered. Thus, by the text, the governor normally acts on his council-dated advice, except where the Constitution itself enters him with an independent judgment. And 200 is an instance of an independent judgment. The article then kindly skipped a couple of paragraphs here. The page 470, paragraph 61, the Constitution itself delineates the fields where a governor may act on his own. For example, Article 239(2) provides that the governor acting as an administrator of a neighboring union territory shall do independently of his Council of Ministers. Special provision 6 schedule and Article 371 likewise particular duties on the governor, so and so are thus exercised at discretion. 365, the extraordinary decree power of the governor is satisfied. The state government cannot function by the Constitution. He may report to the President recommending the President rule, even if his ministers oppose that view. Likewise, 200 provides for the governor's absolute discretion, the limitations stipulated by Tamil Nadu judgment or constitutional amendments. Let me come to then next paragraph, next page at page 471. I am skipping few paragraphs only to address them and to come back after the respondents make their submission. So the post kindly turn to 471, paragraph 68. When you talk about the 4-option theory and how the governor will act under his best judgment, paragraph 68. This position of law.
Can you read 66?
Your Lordship, please.
66 also.
66. Well, the post-1970s constitutional amendments modified the president's duties, but left the governor's role largely untouched. The 42nd Amendment made Article 74(1) explicitly says that president shall act in accordance with so-and-so advice. The 44th Amendment then added a proviso allowing the president an opportunity to return advice or reconsideration. However, Article 163 was not amended to match Article 74. It still speaks in terms of aid and advice, but not a binding shell. Likewise, Article 200 was not altered by these amendments. In effect, therefore, the amendments reinforce that the president is formally bound by advice, with a one-time exception, where the governor continues under the original text to be bound by advice, except where Article 200 other provisions explicitly grant independent authority. Now come to paragraph 68. This position of law is clear, has been stated and reiterated the Honorable Court in Purushottam Nambedri, and later explained by the governor's power, powers in exercising these options in hoist. Let me quickly take only one paragraph of Purushottam Nambedri, which is volume V3, para 15. Anyway, 1194. Para 15.
Yes. 1194.
Five point?
Para 15, Your Lordship. It's at page 1185 or 1194. I don't propose to read the other parts of the
Which page are you referring?
the learned. I'm sorry, Your Lordship.
Which page number are you referring?
Purushottam number.
1194, volume 5.3, paragraph 15. You'll just make a note of that.
1194.
Judgment starts from 1185.
Correct.
Yes, that's right. I'm reading only paragraph 15. The learned solicitor will deal in great length with the couple of judgments. I want to just read a couple of paragraphs only for the purpose of connecting the threads in the context of 200 and 201. May I read it?
Yes.
I'm sorry. It's clear that if a bill pending the assent of the governor or the president is held to lapse on the resolution of the assembly, it is not unlikely that a fair number of bills which may have been passed by the assembly, say during the last 6 months of its existence, may be exposed to the risk consequent on the resolution of the assembly, unless assent is either withheld or granted before the date of the resolution. If you look at the relevant provisions of Articles 200 and 201 from this point of view, it will be significant that neither article provides for a time limit within the governor or the president should come to a decision on the bill referred to him for assent, where it appeared necessary and expedient to prescribe a time limit. The Constitution has made appropriate provisions in behalf. Articles 197, 1B and 2B. In fact, the proviso of Article 201 requires the House, with the bill is remitted with a message from the President, shall reconsider accordingly within a period of 6 months from the date of the receipt of such message. Therefore, the failure to make any provision as to that time within which the governor or the president should reach a decision may suggest that the constitution makers knew that a bill which was pending the assent of the governor or the president did not stand the risk of lapse on the resolution of the assembly. That is why no time limit was prescribed by Articles 200 and 201. Therefore, in our opinion, the scheme of Article 200 and 201 suppose the conclusion that a bill pending the assent of the governor or the president does not lapse the result of the resolution, so and so. Therefore, the court is alive to a variety of situations when the time limit was not mandated in the Constitution, and if at all a mandate, for what good reason. Now, we have an opposite conclusion now reached in the judgment. Now, in pages 472 to 477, I've extracted several other paragraphs from Pavitra, etc. I said I will not trouble lordships at this point of time. Let me quickly go to read one more judgment in this context. That is volume V9. All this on how do you read Article 200 in the proviso, etc. volume V9, page 3768.
Lodi Chaudhary.
It starts at page 3768. Valluri Basavaya Chaudhary versus so-and-so. I just read only two paragraphs in the judgment. Begins at, it is page 3776. 3776.
Which para? Which paragraph you want?
Paragraph 619, Your Lordship. No, no. Paragraph 19. The governor is made a component part of the legislature of a state under Article, Lord Surikant, is that?
3776.
It is volume V9. Page 3776, para 19. The governor is made a component part of the legislature of a state under Article 168 because every bill passed by the state legislature has to be reserved for the assent under Article 200. Under that article, the governor can adopt one of the three courses, namely, he may give his assent, it bill becomes a law. He may accept in the case of money bill withhold his assent therefrom, in which case the bill falls through unless the procedure indicated is very important. In which case the bill falls through unless the procedure indicated in the first proviso is followed. That is, return the bill to the assembly for reconsideration of the message, or he may, subject to ministerial advice, reserve the bill for the consideration of the president, in which case the president will adopt the procedure laid on Article 201. The first proviso to Article 200 deals with the situation where the governor is bound to give his assent where the bill is reconsidered and passed by the assembly. The second proviso, I'm just skipping it, there's a few lines later, that is clear that a bill passed by a state assembly will become a law if the governor gives assent to it, or if it has been reserved by the governor for the consideration of the president, it is assented to by the president. The governor is therefore one of the three components of the state legislature, the only other function, etc. But what is important in this paragraph is in the middle of it where I read that in case the bill come to fourth line, second para 1, 2, subpara 1, 2, he may accept in the case of a money bill withhold his assent therefrom, in which case the bill falls through. In which case the bill falls through unless the procedure indicated in the first proviso is followed. This is the reasoning here. I'm not entering a discussion. So Valluri Vasaya has a bench of 5 judges. It says it will fall through unless a procedure to the proviso is followed. I'll presently try to explain if the reading of the proviso will probably sync with what the Tamil Nadu judgment talks about. So this is one thing I want to bring to your Lordship's notice. Then I'll take your Lordships to one more judgment, Samsher Singh. It is V7. V7 page. It begins at page 2886. Para 54. Page.
This is a different volume.
Page
7.
2903, para 54.
47.
The provisions of the Constitution.
1 minute. Paragraph number 40.
2903.
Yes.
Paragraph 54. The provisions of the Constitution which expressly require the governor to exercise his powers in his discretion are contained in articles to which the reference has been made. To illustrate, Article 239 to state that the governor is appointed an administrative and adjoining union territory. He shall exercise his function as such administrative independently as consular minister. The other articles which speak of the discretion of the governor and so or paragraphs 9 to 18.3, 6th schedule, articles so and so, etc. The discretion conferred on the governor means that as a constitutional or formal head of the state, the power is vested in him. In this connection, reference we made to Article 356, which states the governor can then report to the president the situation as anything with the government of the state cannot be carried on in accordance with the provisions of the Constitution. Again, Article 200 requires the governor may reserve a consideration any bill which, in his opinion, if it becomes law, would so derogate from the powers of the High Court, etc. Then, paragraph 56. Para 56, similarly, Article 200 indicates another instance where the governor may act irrespective of any aid and advice of the Council of Ministers. In such matters, where the governor is to exercise his discretion, he must discharge his duties to meet the best of his judgment. The governor is required to pursue such course which are not detrimental to the state. This is again a larger bench. That's all right. I'll just conclude my submissions with your Lordship's attention to questions 13 and 10 at page 513. I'll only broadly indicate that the court has invoked Article 142 powers, page 513.
You are done with submission?
Yes. They have clubbed up question number 13 and 10 together at page 513 of my written submission.
Okay.
I'm not going to.
142 that is the main thrust.
You will cover it.
Number 10. 10 and 13 together. 13 and 13 together.
We have clubbed question number 13 and 10 together because as some have said, there's a intrinsic connection. Question 13 and 10. Question 13 reads like this. Are the powers of the Supreme Court under Article 142 limited to matters of procedural law, or do they extend to issuing directions and orders contrary to or inconsistent with the existing substantive or procedural provisions of the Constitution or other laws in force? And question number 10, can the exercise of the constitutional powers and orders or the precedents of the governor be substituted in any manner under Article 142? Now, questions 10 and 13 are both related to the scope and powers of the Supreme Court under Article 140 of the Constitution of India. The response to question number 13 will be answered first, and question number 10 will follow. I don't read Article 142, we all know of it too much, except saying complete justice in a cause or matter pending before it. On the rule of inherent powers, paragraph 133. The rule of inherent powers as its source in the maxim. When the law gives anything to anyone, it gives also all those things without which the thing itself could not exist. A power cannot exceed its own authority beyond its own creation. It is not that a person is remediless, where the person is remediless. On the contrary, the constitutional remedy of writs is available. Inherent powers can be exercised only to prevent the abuse of process of the court and to secure the ends of justice. The scope and extent of the power under Article 142 is the subject matter of several decisions. It would be opposite to first state the trite position that the powers of the court in 142 are of wide amplitude. However, the power is primarily a supplementary one for the purpose of doing complete justice in a matter. Italy phrase is supplement and not supplant, as is stated in Devinder Singh. Therefore, the qualifying feature of the scheme of Article 142 can be said to be the express statutory provisions will not be ignored, and relief which is inconsistent or which would militate against substantive statutory provisions may not be granted. This has been emphasized time and again with the Supreme Court illustrated to the following extract. This Honorable Court in Supreme Court Bar Association held as follows. The plenary powers of the court under Article 142 are inherent in the court and are complementary to those powers which are specifically conferred on the court by various statutes, although are not limited by those statutes. These powers also exist independent of the statute, the way to do complete justice in the party. These powers are a wide amplitude and the nature of supplementary power. And stopping in for a minute, complete justice between the parties is at the level where individual adjudications which do not present an easy resolution and need to have a complete justice issues. Then the court resolves those matters. Of course, we have traveled beyond that individual adjudication, individual parties. The court has laid down guidelines, etc., invoking 142 powers. But I suppose there are certain limitations when you want to do that. So kindly read it further. These powers are a very wide amplitude and nature of supplementary power. This power exists as a separate and independent base of jurisdiction apart from the statutes. Then few lines later, this plenary jurisdiction is thus the residual source of power. This court may draw upon as necessary whenever it's just and equitable to do so, and in particular, to ensure the observance of due process of law to complete justice between the parties while administering justice according to law. There is no doubt that it is an indispensable adjunct to all the powers and is free from the restraints of jurisdiction and operates as a valuable weapon in the hands of the court to prevent clogging or obstruction to the stream of justice. It, however, needs to be remembered that the powers conferred on the court by Article 142, being curative in nature, cannot be construed as powers which authorize the court to ignore the substantive rights of a litigant while dealing with the cause pending before it. This power cannot be used to supplant substantive law applicable to the case or a cause under consideration of the court. And Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier by ignoring express statutory provision dealing with the subject and thereby to achieve something indirectly which it cannot be achieved directly. These are very important words of caution. The construction of Article 142 must be functionally informed with the salutary purpose of the article to do complete justice between the parties. Then in the next paragraph, middle of that, the underlying portion, the very nature of the power must lead the court to set limits for itself, within which to exercise those powers, and ordinarily it cannot disregard a statutory provision governing a subject, except perhaps to balance the equities between the conflicting claims of the litigating parties. That will always be the governing factor by ironing out the creases, etc. Now, kindly turn to page 516. I'll just make a note of the judgments. They all talk on the same wavelength about how the power under 142 will be so excised, keeping in mind the balance required in invoking it as a situation may arise. To therefore enter into a 142 jurisdiction to say that I will deal with Articles 200 and 201, where the way it did not exist earlier. So that's what I read out to paragraph 47 at page 515. Now kindly turn over to page 518. I have referred to a few other judgments. We go back in point of time in para 138, we go back in point of time to Premchand Garg. Page 138 bottom, paragraph 12. The powers of this court are no doubt very wide and they are intended to be and will always be exercised in the interest of justice. But that is not to say that an order can be made by this court which is inconsistent with the fundamental rights guaranteed by Part 3 of the Constitution. An order which this court can make in order to complete judgment parties must not only be consistent with the fundamental rights guaranteed by the Constitution, it cannot be inconsistent with the substantive provision of the relevant statutory laws. I only substitute the relevant constitutional provisions. Then the same vein, we have Devinder Singh v. State of Punjab, and next at pages 519 and 520, we have State of Karnataka v. Oneindia. Yeah, they did. In State of Punjab v. Devinder Singh at page 519 bottom, paragraph 690. It's a recent judgment. It's a recent judgment to this court. The affirmative actions of the states have to be within the constitutional framework. And if they are not, the courts cannot ratify the same by bending or molding the specific mandates contained in the Constitution. Article 142, even with the width of its amplitude, cannot be used to build a new edifice where none existed earlier. That's what the judgment says, by ignoring constitutional provision dealing with the subject and thereby achieving something indirectly, which is cannot be achieved directly. Now, kindly turn over to page 521. 520, kindly see Karnataka's versus Uma Devi. No, even at the top of para 520, para 693.9. The action of the state, though well-intentioned, affirmative in nature, if violates specific so and so, cannot be validated. Supreme Court jurisdiction Article 142. If that is the logic, I do not know whether the 142 can be exercised to bend or mend the constitutional provision for to do complete justice in a cause or matter. Will you do that? Precisely what has happened here. I only read a couple of paragraphs from the judgment, and then I would have done. Kindly turn to page 521. Because the court has also said, because there is a failure on the part of the governor not acting according to the scheme of Article 200. The way the court read that, the court said, I am going to give a deemed assent. Para 140. To answer question 1, it will be therefore stated. The Supreme Court itself, being a judicial authority deriving existence and powers from the Constitution of India, cannot in exercise of jurisdiction 142 do violence to the constitutional scheme which identifies specific roles of the executive, the legislature, and the judiciary. Where either the Constitution or a statute occupies a field, room for invocation of Article 142 would not arise. The key words in Article 142, namely doing complete justice in any cause or matter, are sufficient guidelines for the exercise of powers in 142. Even while exercising judicial review of actions of the executive or the legislature, within the confines of the Constitution, the Supreme Court cannot step into the shoes of the authorities exercising legislative functions, because doing so will ipso facto amount to transgressing the sacred boundaries emanating from this scheme. Exercising the wide birth of powers under Article 142, however, cannot give birth to a license in favor of the judicial wing to violate the basic structure of the Constitution and indirectly perform legislative and executive function, either actively or passively, by creating legal or deeming fictions. As an example, the grant of approvals, clearances, licenses, or lease under any statute, which would be purely executive actions, may be considered. In the absence of express provision for deemed grant of these matters, for instance, in the minor mineral concession rules, if an application for a license or a lease is not dealt with before a particular period, there shall be therefore we have an express provision providing for something to deem to take place. So by invoking Article 140, the court will not proceed to grant approvals, clearances, licenses, etc. In the light of the above proposition, there can be only the designated authorities, namely the governor or the president, who are authorized to give assent. No other person, including this honorable court, can arrogate itself the power to grant assent. This can also not be done by inventing the idea of a deemed assent. All this will be outside the scope of Article 142. And there's a judgment in Pera Rivalan, which the Tamil Nadu judgment places reliance upon. I was at the fifth line of this paragraph. The judgment in AG Pera Rivalan, which relates to life and liberty for invocation of Article 142, cannot be extended to any other to any other situation. Any impossible extension has occurred in the Tamil Nadu judgment is a matter open to consideration, and the invocation of Article 142 must necessarily reside within its legitimate limits. Question therefore deserves to be answered, that any sanction to a bill by the court in any manner will be outside the scope of Article 142. It is these aspects discussed in the paragraphs above, along with the submission, the answer to questions 5 and 7, relating to timelines imposed by Tamil Nadu judgment have necessitated question 10 and 13 as to the view or state of law in respect to the scope of Article 142. I'll propose to read a couple of paragraphs of judgment and then conclude for the day. Kindly turn to, this is in, the judgment is in V31. The Tamil Nadu judgment is in V31.
Paragraph, page number?
I just give it to Lordship. Para 317. At page 12454.
Yes.
Tamil Nadu judgment.
Three 317. The governor,
Wait.
Lord Chief Justice got it? One, 2, 4, 5, 4. The confusion is 34. So 34. May I read it?
Yes.
The governor under the constitutional scheme is no longer envisaged as the governor under the Government of India Act 1935, having the ultimate power to veto any legislation, subvert the collective will of the people being expressed the legislature. Is the power to withhold doesn't. Kindly skip a few lines and come to a sentence running like this. It would have the potential of, that is, decide a course of action notwithstanding the aid and advice of the Council of Ministers. It would have the potential of turning him into a super constitutional figure, having the power to bring to a complete halt the operation of the legislative machinery of the state. The governor cannot be vested with such a power. The exercise of such would enable him to collude with the union cabinet. There are two strong things to state. And to ensure the death of any and all legislations limited, initiated by the state merely by reserving for the constitution of the president, who is not under Article 2 and 1 is not bound to give assent to any legislative for consideration. Then I read one para 434. 437. Page 12561, paragraph 432. The conduct.
Paragraph 432.
432. 12561. The conduct exhibited on part of the governor, as it clearly appears from the events that have transpired even during the course of the present litigation, has been lacking bona fide. There have been clear instances where the governor has failed in showing due deference and respect to the judgments and directions of the court. In such a situation, difficult for us to repose our trust and remand the matter to the governor with the direction to dispose of the bills in accordance with the observation made by his judgment. Article 142 empowers this court to do complete justice on the facts of this case, more particularly in the light of the fact the option of granting assent to the repassed bill was the only constitutionally permissible option available to the governor. We deem it absolutely necessary and appropriate to grant that very relief by exercising our extraordinary powers. no meaningful purpose would be served by keeping the bills, some of which have been pending for incredibly long periods, pending for more time. Therefore, we deem the assent to have been granted. I don't propose to read all of them.
33 is what we want.
Where 434 has a long list of conclusions, and the summary of the findings is available from page 12577. Page 12577 onwards.
125?
77. 404.
But on facts, but the facts which are noticed in 431, is it correct actually? That
No.
2020 bills are pending.
One.
No, I think.
Hmm?
He's asking if this is actually correct.
Yeah, that's factually correct. Let's say even if it's factually correct. But there are so many bills which were sent back so quickly. There are some bills which were not sent. That's the dynamics. In fact, I didn't want to go into the facts of that case because I appeared in it.
432 appears to be the reaction of 431.
There were certain explanations given to that, but the court rejects all that explanation. There are long reason why probably the governor kept them without giving his assent for a long time. So we are not going into those reasons. We're not talking about that particular conclusion drawn on those particular facts in the judgment. We are only talking about the state of law. And a state of law, will you say, I will invoke my 142 power and said, I'll give deemed assent. That has to be tested.
But 433 talks about the reason for exercising that power. Very detailed.
I thought, which paragraph?
433.
433.
I would have a nuanced argument on that. Dehorse the fact.
We are not asking your lordship to get into any re-evaluation of those facts.
You don't want to go into the facts.
We are not asking that.
No.
The question is, given a certain set of facts, even though they are so
glaring.
correct, right,
But in
not
this
palatable.
case, there is no pudding.
They're not
Proof of the
palatable.
pudding.
You say, look here, I will enter into the shoes of so and so and do what the governor would have done. I mean, that is we are talking about a constitutional function. We are not talking about a diverse and a marriage, etc. It is a very different field altogether. Only one more paragraph I would read and then leave it to your lordship's consideration of how to evaluate this. It must be in the judgment. I'm only presenting a broad overview of how certain disquieting features of the judgment, because now is a precedent. The judgment says I follow the Punjab state of Punjab case. It's one of the honorable judges of party to the Punjab case. Therefore, it is now the status of a precedent. And then how do you, that's why I told you last in the morning, I have so many judgments of the Supreme Court on my table. The president sees that.
Certainly, you also enlighten us
Yeah.
that if these are the facts before a constitutional court,
Yes.
431 and 433,
Yes.
and if, according to you, the court went wrong in 432, then what else should be the constitutional permissible recourse
No, that the-
for a constitutional
Correct.
court to exercise
I see that.
jurisdiction?
That's for we're not asking the lordship to say whether the lordship may answer that question. If there is such a set of facts where the court probably has no other option, I ask myself a question, would the court still say, I will do what the governor will do? The court will again say probably why the governor must be asked to find out what is the best course of action which should you follow. It must send back to the governor in any circumstance. Then otherwise you're taking over the functions of a governor. It can be taken over in any circumstance in future. Like no limits can be drawn, no lines can be drawn.
But in 532, there is also finding that there have been clear instances where the governor has failed to in showing due deference and respect to the judge.
If your lordship want me to go into the facts, there's some disquiet about it. I didn't want to go into the facts. I assume that there is something with the court has said. I'm not even disputing the assessment of facts. I assume against myself. But even if it is so, but if you're sitting in a judgment or a review, perhaps I would have asked your lordship to go into them. I am not doing it for the time being.
Can't it be seen as a egregious situation which has come to existence? So therefore, in order to get over that, the court has stepped in to ensure it is not in the form of a laying a precedent. It is to handle a situation like
it is.
432 and 433 is handling a situation like this, in a situation where for such a long time it's pending.
What I'm trying to say is the precedent value which will now emerge like this. So you can always extend this to any fact situation, minimal or otherwise, and say, now apply this law. Ask the governor to give deemed assent. The moment the court enters into this arena, then you have any kind of mind-boggling facts where the court may have to be confronted with. Therefore, I want to take it away from the fact situation and say, even if it is so, can this be done? So kindly read only one more paragraph, para 184 of the judgment. Wait, look at this page. That's right. Page 12333.
Just tell us the para number.
Para number, just read para number 183, then 184. Para 183 and 184. I refer to Valluri Basavaya and says the bill will fall unless the first proviso procedure is followed. Kindly turn to paragraph 183, placing reliance on the expression unless the procedure indicated in the first proviso is followed. So submitted. The decision as regards whether the procedure prescribed in the first proviso is to be invoked or not is the discretion of the governor. Is only when the governor decides to return the bill along with the message that so-and-so would come into play. In other words, if the governor believes that the bill is constitutionally infirm and beyond any remedial changes, then he may choose not to return the bill along with the message and may simply declare that he is withholding assent to the bill, in which case the bill would fall through or lapse. Although the argument is seemingly lucrative and appealing, and the petitioner also could not provide a concrete reply to the same during the course of argument, and instead took shelter in the semantics of obiter dicta and ratio decidenty, yet we deem it necessary to explain that the argument is short-sighted, half-baked, and suffers from inherent fallacy. If at all your lordships want me to give a narration of the facts, if at all it is desirable, but I don't think that would be required.
Better not go there.
That's right.
Cannot be done. Cannot be.
So I've done for the day, and I've kept certain things reserved for the reply. The learned solicitor will deal with all the other issues, and that's how we shared our share of submission. I'm grateful to you, Lord.
Wait, please. Not a very right time to begin a fresh argument. But I'll just, Lord, on the lighter side, I'm saying, Lord, your lordships are not concerned with the facts of the case. There may be few errant cases of errant governors, ministers, wrong advice, right advice, time lag, etc., etc. what is essentially, my lord, the core of the issue which is considered by your lordships, and that is something of a very, very high significance in the democracy of this country. My lord, in our republic, such question has come for the first time before your lordships, and I'm sure your lordships would not go by facts of an individual case. My lord, your lordships would be able to better advise the president only if I can show to your lordships what is the role of the honorable president and governors in maintaining a federal balance which is envisaged by the Constitution of India. Second, there may be, my lord, cases where, Lord, the Constitution has always done two things, and I will show, my lord, from the Constituent Assembly debates. Whenever we are either making a constitution or we are interpreting a constitution, we do it on an idealistic plane. That this is how each constitutional functionary would work. This is the parameters within which they would function. There may be some deviance here, sometimes in the executive, sometimes in the legislature, sometimes in the judiciary, and there is an inbuilt check and balance. But while framing the constitution, fortunately, our forefathers, my lord, the framers of the constitution were visionaries. They have examined a potential abuse also. They have kept what they are doing in mind, and each and every provision which is made is so designed that it maintains the balance. There may be some problems, my lord, which may confront, but all problems may not have a solution in the court of law. There may be several problems, my lord. I can also give illustrations of problems, but that may not be, my lord, that the problem will be ultimately solved by the judiciary. Lord, for answering this question, your lordships will have to have a holistic reading. I'm sorry. Lord, in a deaf and dumb school, there is a course of lip reading. Lord, I think in all law universities, that course would be mandatorily introduced.
But I think the lawyers are experts at that.
Lord, we can only, my lord, make a wild guess, my lord, without knowing the real conversations. My lord, for the purpose of, my lord, advising the honorable president, my lord, this is not a list between, my lord, other side and this side and that side. The honorable president is requesting your lordships to give an advice. My lord, the advice will be possible if your lordships can take a holistic reading of 5 articles.
Right?
5 articles of the Constitution. And within these 5 articles, I think, my lord, your lordships will be able to, my lord, advise the honorable president what is the correct position in law. My lord, we forget Tamil Nadu, we forget judgments, we forget facts. There may be, my lord, errant instances, etc. My lord, I'm not going in.
Fortunately, you stopped at instances.
Yes, yes, sir.
Preceded by error.
Lord, one is Article 111. Lord, that is the power of the president to grant assent. Second is Article 74. The Council of Ministers in the Union and their power, function, role, duty, whatever, my lord, we may call, to aid and advise the President of India. Third provision is Article 155, the appointment of the President, appointment of the Governor. Fourth, Article 163, which is Council of Ministers to aid and advise the Honorable Governor in discharge of his functions, and what are the differences between the power of the President and a conscious choice of words by the Constituent Assembly while defining the powers of the Governor. And last would be, my lord, this dual power, Article 200, my lord, the assent giving power of the Governor, and on reference, the power of the President of India. But if these 5 provisions are, my lord, examined by your lordships, my lord, your lordships will be able to, in my respectful submission, reach a conclusion as to what advice your lordships would like to give, my lord, on several questions, my lord, most of which would be covered under this. There are certain subsects of the questions, my lord, which, of course, my lord, I will assist your lordship differently. My lord. So, my lord, I am treating 200 and 201 as one, my lord, group. Otherwise, it would be 6 provisions.
Part of one scheme.
Yes, part of one scheme. My lord, for this purpose, my lord, the exercise which I want to undertake before your lordships, by way of an assistance, but I am appearing for the central government, for Union of India, and we will be assisting your lordships, my lord. What is the purpose, what is the intent, and what is the object of the Constitution of India, and why a particular constitutional scheme is formulated? For doing that, my lord, what I have done is, Lord, all these 6 provisions or 5 provisions, my lord, have their history. It is not, my lord, coming suddenly, my lord, by way of a constitutional provision in 1947. It has been preceded by their perimateria provisions, my lord. First was Government of India Act 1919, when we were under the British regime. Then came Government of India Act 1935, where almost, my lord, there was a my lord, symbolic acceptance that the India will have to be given independence, and suitably, my lord, the law, though made by the British Parliament, was suitably molded. 3, Lord, there is, my lord, one draft prepared by one Mr. B.N. Rao. He was the constitutional advisor to the Constituent Assembly. He prepares draft for each and every provision. 4th, the drafting committee headed by Honorable Dr. Ambedkar, they draft a particular provision, and which goes before the Constituent Assembly, debated, and the result is what we have now as, my lord, the final provision. Yeah. Lord, your lordships have my written submissions. Lord, it may look thick because my style is, my lord, I quote the relevant paras of the judgment so that your lordships may not have to suffer through.
Not required to.
Suffer through, my lord, yes. Whatever I want to read, my lord, is quoted here. Therefore, it is bulky, otherwise it's not bulky. Lord, please come to article, come to, my lord, page 121.
You don't believe in 1 pages of Dr. Singhvi?
No, my lord.
The loose part is not necessary. You have included it here.
No, my lords. There is a separate volume, my lord. It is 1.1, my lord, if you look. Yes. This. My lord, your lordships have the hard copy or a soft copy. I can use the pagination accordingly.
Same page number. You tell us the page number itself.
121, my lords. I think 121. My lord, first I'll take your lordships to the history of Article 111. Lord, to my knowledge and subject to being corrected, this manner of examining, my lord, what ultimately we have Article 111, that exercise is not undertaken before this honorable court. Therefore, whichever way your lordship's opinion goes, my lord, it would be relevant to bring these facts to your lordship's notice. My lord, this is perimateria or a precursor to the office of the President of India, as we understand today under Article 111. Lord, one more fact, my lord, before I reach this, and my lord, I found out, my lord, during the research of this, it may have no relevance, but according to me, it has tremendous relevance. Lord, there are several constitutional functionaries under the Constitution of India. The President of India, the Prime Minister, the members of Parliament, etc., etc. Lord, there are different oaths which are prescribed by the constitutional provision itself. It is only the Honorable President of India and Honorable Governor who takes the oath not to just not to abide by the Constitution of India, but to defend the Constitution of India. Only two functionaries, my lord. Rest of the constitutional functionaries, my lord, highest at their own sphere, but they take oath, my lord, to respect, aid and abide by the Constitution of India. These are the only two functionaries who take oath to defend the Constitution of India. Now, my lord, please see, my lord, what is the office of the President envisaged during British era. Section 68 of Government of India Act 1915, peri materia to Article 111 of the Constitution provided for. I'm sorry, page 121. My apologies.
Yeah, got it.
121 at the foot. The title is, my lord, Article 111. This is article of the present Constitution. Now comes, my lord, the history for your lordship's assistance. My lord, this is Section 68 of Government of India Act 1915. That is peri materia to Article 111. But I'll read. When an act has been passed at a meeting of the Indian Legislative Council, my lord, Lord, we can say Parliament of the day, Parliament, Indian Parliament. The Governor General, my lord, Governor General is equivalent to the President, loosely, my lord, speaking. Now, we can't compare, my lord, the colonial era with the sovereign,
Appointed by the magistrate.
yes, my lord, sovereign republic, because they used to exercise the power conferred upon them and in the name of Her Majesty or His Majesty, as the case may be. Indian Legislative Council, the Governor General, whether he was or was not present in council at the passing thereof, may declare that the assents to the act, or may declare that he assents to the act. This is the first option. Or that he withholds assent from the act, second option. Or that he reserves the act for the signification of His Majesty's pleasure. So three options in the main provision, in the main part of 68(1). Then subsection 2. An act of the Governor General in Legislative Council has no validity until the Governor General has declared his assent thereto, or in case of an act reserved for the signification of His Majesty's pleasure, until His Majesty has signified his assent to the Governor General through the Secretary of State in Council, and that assent has been notified by the Governor General. There was no provision for returning the bill to the Legislative Council for reconsideration. Only three options were given. His Majesty was, my lord, like the President of India, and no, I'm sorry, my lord, His Majesty had no Indian equivalent. His Majesty was, my lord, the Crown. Governor General was the President of India, and Legislative Council was the Parliament. Now, my lord, Section 32 comes in 1935 Act, where, my lord, we were almost in principle, my lord, it was agreed that the India will have to be made independent because of, my lord, the efforts made by everyone, my lord, who was in the freedom struggle. Assent to bills and powers of Crown to disallow acts. When a bill has been passed by the chambers, now the Parliament is present, the chambers is present equivalent of Parliament. By the chambers, it shall be presented to the Governor General, that is President, and the Governor General shall, in his discretion, please mark this, my lord. This word, my lord, is, my lord, while drafting the Constitution, is removed. My lord, something turns on that, my lord. I must tell your lordships, my lord. Therefore, in his discretion, declare either that he assents to His Majesty's name to the bill, declares in His Majesty's name. He used to do all his works in name of His Majesty, or that he withholds assent therefrom, or that he reserves the bill for signification of His Majesty's pleasure, provided that the Governor General may, again, my lord, in his discretion, return the bill. Kindly mark, my lord, two important facets. Discretion in the main section, and now, my lord, proviso comes, which is, my lord, our equivalent of 2000 proviso, the 200 proviso. Just I'll come to that, my lord, but just at this stage. Provided that the Governor General may, in his discretion, return the bill to the chambers with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendment as he may recommend in his message, and the chambers shall reconsider the bill accordingly. Now, if the chamber does not do it, what is the consequence? Not provided. Whether it would go back, whether the Governor General can thereafter withhold, not provided. Number one. Number two, there was a discretion in the first part and there was a discretion in the second part. But now becomes a scenario of the Governor General having four options. He can grant assent, he can withhold, he can refer it to His Majesty, and fourth, he can return the bill with a message. Message can even include desirability. My lord, sometimes, my lord, in working of the Constitution, what happens is the governor sends it back saying that this particular provision might be repugnant because there is already a central act. So you may need to consider. He may also say that this particular provision might violate somebody's fundamental right, and therefore you might consider. Based upon, my lord, the situation in the state, he might even say that it would be desirable that either delete this provision, add this provision, dilute this provision, etc., etc. And then thereafter
that is provided in Article 200 itself.
200 itself now, but it was there earlier also. Desirability also, the governor can send a message. This is how the democracy is contemplated to work, and this is how the governor-assembly relationship has been envisaged from the beginning. Now, my lord, 2. A bill reserved for the signification of His Majesty's pleasure shall not become an act of the federal legislature unless and until. Now, please mark, there was a period prescribed. Now, my lord, we are dealing with a situation where one of the questions the Honorable President is posing, my lord, for your lordship's my lord, guidance is whether there can be a timeline prescribed. Apart from the question that by a judgment, but there can be a timeline prescribed. My lord, my respectful endeavor will be that there was a timeline, it was done away with consciously. It's a conscious omission on part of the Constituent Assembly. Within 12 months from the day on which it was presented to the Governor General, the Governor General makes known by public notification that His Majesty has assented thereto. Any act assented to by the Governor General may be disallowed by His Majesty within 12 months from the day of the Governor General's assent, and where any act is so disallowed, the Governor General shall forthwith make the disallowance known by public notification, and as from the date of notification or the act has become shall become void. Well, two things. There is a timeline stipulated for the Governor General, timeline stipulated for His Majesty the Queen, and after that, forthwith, which is a word with inherent element of urgency, he has to notify. Now, my lord, Dr. B.N. Rao, the advisor to the Assembly, my lord, when he prepares the bill for the independent India, my lord, bill was prepared when India was not independent, but India was going to be independent because your lordships are aware the Constituent Assembly started its debates before 15th of August 1947.
In 1946.
Yes. So they were making a constitution for the sovereign democratic republic. Now, my lord, this is what Dr. B.N. Rao, my lord, formulated, which became ultimately Article 111 as we see today. When a bill has been passed by houses of the federal parliament, it was initially envisaged as a federal parliament, not only parliament, it shall be presented to the president, and the president shall declare either that he assents to the bill or that he withholds assent therefrom. There was no His Majesty, so there was no question of president referring for assent of anyone. Provided that the president may, please mark, my lord, again a time limit, not later than 6 weeks after the presentation to him of a bill for assent, return the bill, if it is not a money bill, to the houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message, and the House shall, reconsider the bill accordingly. My lord, if the House does not consider his message or considers it partly or fully, what would happen? No consequence stipulated by Dr. B. N. Rao. Then, my lord, draft constitution is prepared by the drafting committee, my lord, chaired by Honorable Dr. B.R. Ambedkar, my lord. That is, Article 91 is the draft bill which came before the Constituent Assembly for debate. When a bill has been passed by the Houses of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. Only two options, because the crown goes. There was no third option. Now India is a sovereign democratic republic. Provided that the President may, not later than 6 weeks after the presentation to him of a bill for assent, return the bill, if it is not a money bill, to the Houses with a message requesting that they will consider, my lord. Same remains as Mr. Rao has suggested. There is no change. Now, my lord, very interestingly, this is debated in, my lord, the Constituent Assembly, and your lordships may, my lord, get what was the intention, object and intent of the framers of the Constitution on this, my lord, when we got 111, my lord, as we have today. On Mr. President, we shall take up the next Article 91, my lord, precursor of 111. Article 91 from the Constitution. Now, Sri Loknath Mishra, that in Article 91, for the words, well, kindly see, he suggests two amendments. There is a likelihood of some misunderstanding. Therefore, I'll read it carefully. He is suggesting two amendments. That in Article 91, the words, either that he assents to the bill or that he withholds assent therefrom, the words, that he assents to the bill, be substituted. His power of withhold was suggested to be not conferred upon him. And the following words be added. Now, second amendment he is suggesting, that is, and if the bill is passed again, I'm sorry, following words be added in the end of the proviso to the article. When he returns with some message and it is presented before him, what should be done? Second amendment suggested by Sri Loknath Mishra is, and if the bill is passed again by the House with or without amendment and presented to the President shall not withhold assent therefrom. This is what was suggested to be added. First was that take away the power of withholding. He can either assent or return it to the House, and if the House does something or does not do anything, he will have no power of withholding. Now, sir, in moving this amendment, I am in the best, beat is an original typo, not here. Originally, it is typo, it should be best. In a best of the company, insofar as the drafting committee itself has suggested the same in a subsequent amendment. I beg to submit that when I move this amendment to take away the power from the President to dissent from any bills passed by the Parliament, I mean nothing more than saying that since our President is analogous to the King in England, and as the King has no power of dissenting from any bill passed by President, this amendment is appropriate. As regards the second amendment, that is after returning by the House, second amendment, without that amendment, the proviso seems to be incomplete. Supposing the President sends back a certain bill for reconsideration and Parliament comes to a certain decision, without this amendment, the whole action becomes incomplete and inconclusive. And since this is also the view taken by the drafting committee, this amendment too should be accepted. The Honorable Dr. Ambedkar, that in the proviso to Article 91, for the words not later than 6 weeks, the words as soon as possible be substituted. Lord, kindly mark this. The draft contained a time limit, and Dr. Ambedkar was pleased to suggest that remove this time limit, make it as far as possible.
As soon as possible.
Pardon?
As soon as possible.
As soon as possible. It was a slip of tongue. As soon as possible. That in amendment number so and so of the list of amendments.
According to no time limit was provided. So earlier time loan was provided in the draft constitution.
It was sought to be deleted for good reasons, my lord, that ultimately the power is conferred on the highest executive. He may not be bound by the time limit that you better decide in 6 weeks as far as possible, because we always, my lord, follow a system that highest constitutional functionaries will discharge their duties in accordance with law. They are not supposed to be. Lip reading. Even if you're, therefore, Marad, even if your lordships do not do this, that would be fine with me, Marad.
They might read the lips.
They might. Now, my lord, Mr. Nazimuddin Ahmed, yes, sir, I beg to move that amendment number so-and-so in the list of amendment in the proviso to Article 91 for the proposed verb possible, the word may be substituted. I beg to submit that this amendment will make some substantial changes. The proviso is to be to the effect that the President may, as soon as possible after the presentation of the bill, return the bill, and so on. I want to make it as soon as may be. He says as soon as possible. Instead, make it as soon as maybe. It's that distinction without difference. But my lord, there were many members who always used to suggest, my lord, something just for the sake of suggesting. If we leave it exactly as Dr. Ambedkar would have it, it leaves no margin. As soon as possible means immediate.
Some members only use proxy.
Yes. Possibly, which means physical possibility is the only test. It may leave on breathing time to the President. The words maybe give him a reasonable latitude. It would mean reasonably practicable. This is the obvious implication. That is the only reason why I have suggested the amendment. Then, my lord, I come to T.T. Krishnamachari. There is a slight difference in language. I think Dr. Ambedkar's proposal will be the better one. But Dr. Krishnamachari, my lord, Mr. T.T. Krishnamachari has always, my lord, been, my lord, fair. And there were two members I come to.
He was a part of the drafting committee.
He was a part of the drafting committee. But one Mr. H.D. Kamath and someone else, my lord, he always used to oppose Dr. Ambedkar. But I'll show. Appears, my lord, I write and research H.D. Kamath. H.V. Kamath.
And Mr. Naziruddin Ahmed also.
Yes. But he was H.V. Kamath was a brilliant, must be a brilliant man. He was an ICS officer.
Mr. Naziruddin Ahmed also used to oppose
almost all amendments, even the main provision of Dr. Ambedkar. Mr. H.V. Kamath was a former ICS officer. He thereafter resigned as a part of freedom struggle. Then he contested the election and lost. He challenged his election before the Supreme Court and won the matter. Again,
Hari Vishnu Kamath.
Hari Vishnu Kamath. Yes, yes. Hari Vishnu Kamath. Your lordships are right. He again won and became the member of parliament. And he was the one, one of them, nothing to do with this matter, but he suggested that travel to space should be included in the first list. He appears to be a maverick, intelligent, but he always used to oppose Dr. Ambedkar. Beside the point, just as a interesting information. Then, President, I shall put this to vote. It need not be moved. Amendment number so-and-so, this is also the same as amendment number so-and-so of Dr. Ambedkar. We have taken it as having been moved. Is it necessary to move this? You can move it. Is there in some slight difference? Then Begum Azaz Rasool, my lord, I can, my lord, skip that. My lord, your lordships need not. I'll not, my lord, trouble your lordships. This is put for completeness. Then Dr. P.S. Deshmukh. Mr. President, sir, obviously the article it was worded in the beginning was found to be defective in at least two particulars, as is clear from the fact that Dr. Ambedkar himself has moved one amendment suggesting the substitution of the words not later than 6 weeks by the word as soon as possible. The second difficulty which has been visualized and which is tried to be removed is by making a provision in case the President withholds the assent. The provision intended is that when a bill is presented for a second time, it shall be incumbent upon him, that is the President, to give his assent, and he shall not have the option to withhold the assent. So far as the first amendment of Dr. Ambedkar is concerned, I do not know if it is very necessary that the amendment should be accepted. The question for consideration is whether we should merely say that the President should give his assent as soon as possible, or whether we should state any period within which he should do it. I think if the words not later than 6 weeks are to be left as they are, then it is the duty of the President to indicate his decision as early as possible and in no case later than 6 weeks. So I am not fully convinced of the propriety of changing the wording as proposal. Then President, I would now put the amendment to vote. Do you want to say anything, Dr. Ambedkar?
Mr. Mehta, Mr. P.S. Deshmukh was also the third one.
Yes, your lordships are right. And I do not know about.
He was the first agriculture minister of India.
That I did not know. Dr. Ambedkar was the first law minister.
Dr. P.S. Deshmukh was the first agriculture minister.
And the first lady was Rajkumari Amrit Kaur, first, I think, education minister.
Comet was called the enfant the terrible.
Hmm?
It's called the infant the terrible, the French word. The terrible infant.
Lord, then the President says that would Dr. Ambedkar like to say something on this? Then, Lord, many a times Dr. Ambedkar, my Lord, appears to be frustrated. Nothing more is to be required to be said. Lord, this is one of that line. No, sir, I do not think any reply is necessary. Then President, then he puts it to vote. Then Mr. President, my Lord, a bold part, there is one amendment left over. That is so and so moved by Dr. Ambedkar. There is an amendment to it moved by Dr. Naziruddin Ahmed. I would first put Mr. Naziruddin Ahmed's amendment to vote. That in amendment number so and so of the list of amendments in the proviso to Article 91 for the proposed words possible, the words maybe be substituted. Amendment negative. The President, now I put amendment 1685 that in the proviso to Article 91 for the words not later than 6 weeks, the word as soon as possible be substituted. The amendment accepted. And this is now, my Lord, page 125 bottom at page 126 is the Constitution, my Lord, 111. I'll read it, my Lord. This is what we have right now. When a bill has been passed by the House of Parliament, it shall be presented to the President, and the President shall declare either that he assents to the bill or that he withholds assent therefrom. So both the options and only two options are given because he has no option of referring to anybody above him. He is at the, my Lord, peak of the constitutional framework. Provided that the President may, as soon as possible after presentation to him of a bill of assent, return the bill, if it is not a money bill, to the Houses with a message requesting that they will reconsider the bill or any specified provisions thereof, and in particular will consider the desirability of introducing any such amendments as he may recommend in his message. And when a bill is so returned, the House shall reconsider the bill accordingly. And if the bill is passed again by the Houses with or without amendment and presented to the President for assent, the President shall not withhold assent therefrom. So, power of assent, power of withholding.
So the discussion appears to be that it has to be done within a reasonable period.
As far as possible, yes.
As soon as possible.
Correct.
As soon as possible.
My Lord,
So
I may again, my Lord.
some of the speakers thought that even a 6 weeks period is longer.
No. Don't bind him down. That is the idea.
So therefore, one of the honorable members suggested that as soon as possible, but not later than 6 weeks.
That was original. Kindly have a look.
Originally was within a period of 6 weeks.
Yes, my Lord.
Then Dr. Ambedkar recommended, Dr. Ambedkar suggested an amendment instead of 6 weeks, as soon as possible. So when there was a discussion on these two words, one of the honorable members said that the better word would be as soon as possible, but not later than 6 weeks.
So, my lord, in either of the cases, the president was being bound by one constitutional provision in terms of time limit. And that was, my lord, in my submission, consciously given up, that there cannot be any time limit which binds the president of India for doing something. My lord, again, my lord, at the cost of repetition, if your lordships examine the interpretation based upon, my lord, few instances which your lordships
No.
asked
We are not on the instances, we are on the pitches.
Yeah.
Because we can take into consideration the debates in the Constituent Assembly.
Certainly.
While interpreting the provision.
Certainly. There's no doubt about it.
Later than 6 weeks was sent by the drafting committee originally.
Originally.
How
Dr.
else
B.
do we give meaning to the expression as soon as possible?
Drafting
Dr. B. did not put
Certainly, my lord. Right now, I'm not on the contentions.
6 weeks.
BN Rao also said not later than 6 weeks.
So then that was
That
actually
later on
the drafting committee and the Dr. Ambedkar suggested an amendment.
The point is now we have made it 3 months.
Huh?
The point is now we have made it 3 months.
Now we have.
I leave it at that, my lord. But please, again, my lord, do not feel, my lord, in your lordship's mind that your lordships are deciding some extraordinary, my lord, or exceptional cases. That's not, my lord, the purpose of this reference. Reference will have to be decided. Every president, every governor will do their duty in, my lord, right earnest within the right time and at an appropriate stage. But he cannot be bound even by the constitutional framers by a particular time limit. That's, my lord, the point. Now, my lord, section 74. My lord, 74 is the Council of Ministers. My lord, something would turn on this. Therefore, my lord, a history would be necessary. Council of Ministers in the...
But Mr. Solicitor, the other significant addition that ultimately came out in this provision was, if you go by the original 76,
Yes.
at page 122,
Yes, my lord.
where this not later than 6 weeks was there.
Yes, my lord.
At that time, there was no provision that if the president gives an opinion and desires that the House should reconsider, after that reconsideration, what will happen?
The consequence was not provided.
So that suggestion first time comes from Loknath Mishra, page
As a second amendment,
and then
which is accepted.
Begum Rasool, she also pleaded.
Well, I'll read Begum Rasul. I thought, my lord, it may not, but I must, my lord, read it.
It's worth reading.
That, I'm sorry.
So then ultimately it is incorporated.
Yes, my apologies to your lordship. My lord, kindly come to page 124. Lord, I thought it
The context that after the president's opinion has been considered by the House, accepted or rejected, then there is no choice but to.
no choice. I'm my lord saying that. I'm not arguing against that proposition. President of India, that's not a suggestion even at the end of my submissions. The Honorable President has right to either straightway give his assent or withhold the assent. And I'll show, my lord, what is the meaning of the term withholding the assent. But if he chooses the third option of returning it to the House, whether House accepts his message, recommendation, suggestion, amendment or not, and returns it back, he has no option, he cannot withhold, he has to assent the bill. I'm making it very clear and there is no, my lord, ambiguity on that. Please see, my lord, what Begum Azaz Rasool said. That in Article 91, after the first proviso, the following second proviso be added. Provided further that if after the President has declared that he withholds assent from the bill or has returned the bill with a request for reconsideration of the bill or of a specified provision thereof or of any amendment by him, the Houses of Parliament should, after reconsideration of his recommendations, pass the bill again with or without an amendment and return it to him for his assent. He shall not withhold his assent therefrom. Sir, the present provision in Article 91 provides for the action that the President has to take, presumably on the first presentation of a bill. But it does not make it clear that what should be procedure if a bill is returned to the President without accepting any of the recommendations. As my lords have said, 74 is silent of that consequence. Does it mean that he can again return the bill to Parliament for reconsideration of his amendments? This will mean unnecessary delay and will mean that the bill can be returned to Parliament more than once. My object in moving this amendment is to do away with this ambiguity and to make it clear that the President can return the bill to Parliament with his suggestions once only, but if the Parliament does not agree to the amendments that are suggested by him and returns the bill to him, he should not in that case return the bill a second time for the reconsideration of Parliament. In the House of Commons, any bills which has been passed twice by the House of Commons automatically becomes law, even if the House of Lords disagrees. In the same manner in USA, a bill becomes an act even if the President vetoes it, provided it is passed by 2/3 majority of the Congress. Some such provision should be made here in this article also, so that unnecessary delay may not take place. With these words, I move the amendment. This is accepted, my lords are right, my lord, and I should have read it, my lord. Now, my lord, kindly come to page 126. My lord, we are now Article 74. That is, there shall be aid and advice of the Council of Ministers. Lord, please have a look at, my lord, what was the position in 1935. My lord, this came for the first time. It was not there in 1990. This has come in 1935. There shall be a Council of Ministers not exceeding 10 in number to aid and advise the Governor General in the exercise of his functions, except insofar as he is, by or under this Act, required to exercise his functions or any of them in his discretion. This was there. Correct, Manoj? Provided that nothing in this subsection shall be construed as preventing the Governor General from exercising his individual judgment in any case where by or under this Act he is required so to do. Under this Act, my lord, now this has gone, my lord, I'll come little later. The Governor General in his discretion may preside at meetings of the Council of Ministers. If any question arises whether any matter is or is not a matter as respects which the Governor General is, by or under this Act, required to act in his discretion or to exercise his individual judgment, the decision of the Governor General in his discretion shall be final, and the validity of anything done by the Governor General shall not be called in question on the ground that he ought not to have acted in his discretion or ought not to have exercised his individual judgment. My lord, thereafter, my lord, the first draft is prepared, and Article 55 of the first draft, my lord, there were two, orally, my lord, I'll point out, there were two committees constituted. One was Union Committee within the Constituent Assembly. Another was Provinces Committee. Union Committee was headed by Pandit Jawaharlal Nehruji, and a Provincial Committee was headed by Sardar Vallabhbhai Patel. And they both, my lord, Nehruji decided the All India structure, and Sardar Patel's, my lord, committee not decided, my lord, they recommended how the states, and they used to be known as provinces, how the states would function as a part of the overall federal setup which we have envisaged. It's not a federal setup, not as understood in America, that every state is as such independent with its own Supreme Court, etc. We have a different
Its own constitution also.
Its own constitution. The governor is the chief, my lord, in American states. We have, my lord, a different collaborative kind of a federal constitution. My lord. Now, when Mr. B.N. Rao, my lord, prepared section 55 is his, my lord, function. There is his version. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President in exercise of his functions. After a detailed scrutiny, my lord, now draft, my lord, I'm skipping reading. 61 is what the drafting committee drafted. 61, my lord, at page 127, your lordships have. There shall be a council of ministers with the Prime Minister at the head to aid and advise the President in the exercise of his functions. Your lordships would notice the discretion, exercise of powers in his judgment, which was there earlier with the Governor General, is now not available with the President of India. He is supposed to exercise the powers as per aid and advice of the Council of Ministers. The question whether any, and if so, what advice was tendered by ministers to the President shall not be inquired into in any court. Please mark this, my lord. This is the sanctity given to the minister president advice that it is immune from examination even by the courts. Look, there are provisions made under the Constitution where some of the executive acts and legislative acts or quasi-legislative acts are made immune from the scrutiny of the court. That's the balance, my lord, of separation of powers, which I'll ultimately, my lord, assist your lordships with.
9th schedule.
Yeah, yes. Well, other than 9th schedule also, there are certain issues where the Constitution bars any judicial scrutiny. That's, my lord, the fundamental principle, my lord. Then, my lord, how this, my lord, was debated. Yes, my lord, this is how, my lord, this article was debated in the Constituent Assembly. Mr. Mohammad Tahir, Mr. Vice President, sir, I beg to move that at the end of clause 1 of Article 61, the following be inserted. Except insofar as he is by or under this Constitution required to exercise his function or any of them in his discretion. So there was a suggestion that the discretion which is taken away from 1935 Act should be restored. If this amendment is accepted, then the article would read thus. Lord, I'll skip that. Now my second amendment is as follows, that the following new clause be inserted after clause 1 of Article 61. Article 61 is, my lord, precursor to Article 74, present Article 74. And the existing clause 2 be renumbered as clause 3. If any question arises whether any matter is or not a matter as respects which the President is by or under this Constitution required to act in his discretion, the decision of the President in his discretion shall be final, and the validity of anything done by the President shall not be called in question on the grounds that he ought or ought not to have acted in his discretion. Again, my lord, restoring the position of 1935 Act. The Governor General had this discretion, and that discretion will not be called in question, was sought to be amended, my lord, or suggested to be amended while framing the article. In moving these amendments, I want the President of India, although he is a nominal president in the words of my honorable friend, Mr. Kamath. Kindly pause here for a minute. Mr. Kamath always says he is a nominal president. And rest of the, including Dr. Ambedkar, they say that this is a different indirect election method we have adopted. Unlike the queen or king, he is not a successor. He doesn't get his office by succession. He is an elected person, elected by indirect representation of not only the parliament, both the houses of parliament, but even the state legislatures. So he represents the legislative and democratic will and mandate of the entire nation by way of an indirect election, unlike in USA where there is a direct election of the president. But Mr. Kamath has chosen to describe the honorable president as
comparing him with the American president.
Yeah, yes.
Yeah, because in American president, all the powers are vested with the American president.
Yeah, yes.
Here, the president has to act
on the aid and advice.
Fully on the basis of the aid and advice of the Council of Presidents.
Yeah, yes.
His difference would be in that context.
Yes, but he says there is a nominal president. He always, I don't wish to go into it because it's not necessary, but he always found that he is not an elected person. He is not an elected person. That's how he understood it. And my lord, it would come somewhere, my lord, in the debate that he is an elected person. He represents the will of the nation, maybe by way of an indirect election. I elect my MP and my MP elects the President of India. He represents me.
That's why we are a republic.
Pardon us?
That's the reason why we call ourselves republic.
Yes, exactly, my lord. That's the very heart and soul of the term republic. In moving these amendments, I want that the President of India, although he is a nominal president, in the words of my honorable friend, Mr. Kamath, Still, I want that the precedent should not be tied down all around. At least this House should be generous enough to give him the freedom of using his discretionary powers. In introducing this exception, I would submit that it is not a novel exception. If you will be pleased to look at Article 143 of the draft Constitution, you will find that the same exception has been allowed in respect of governors and the ministers of state. The governors still continue to have this discretion, and there is a debate why that discretion is conferred on the governor. That is essence of the federalism, which has a unitary tilt. But at the same time, the governor is supposed to exercise certain other functions, my lord, and therefore that discretion continues with the governor. When the governor of the states have been given power to exercise certain powers in their discretion, I do not see any reason why this innocent power should not be granted to the President of India. I need not make any long speech in this connection. I close my speech with the hope that my honorable friend Dr. Ambedkar will consider this question seriously and decide in favor of my amendments. Then, my lord, amendment is negative. The discretion does not remain now in Article 74. So, my lord, this amendment suggests earlier was there in 1935, not there in the draft article, sought to be inserted and not conferred. Now, my lord, final draft as it stands today, there shall be a, my lord, on page 128, there shall be a council of ministers with the Prime Minister at the head to aid and advise the President, who shall, in exercise of his functions, act in accordance with such advice, provided that the President may require the Council of Ministers to reconsider such advice, either generally or otherwise, and the President shall act in accordance with the advice tendered after such reconsideration. So he can send it once, but if it comes back from the Council, he is bound. The question whether any, and if so what, advice was tendered by the ministers to the President shall not be inquired into in any court. But again, a constitutional bar against, my lord, any judicial oversight. Now, my lord, Article 155. My lord, this is appointment of the governor.
So far as the President is concerned, only instance where for a long time bill was pending is perhaps the postal bill during jail sale.
Your lordships are right. My lord, there are
for a long time.
Yes, my lord, some of the bills were withheld right from, my lord, our entire journey from 47 onwards. 20-30 bills are withheld, but when we see, we find that they were rightly withheld. For example, one bill was that in state of, I will not name the state, my lord, in one state, the assembly passed an act that before registering yourself in the employment exchange, you have to take permission of the state and you have to be a man of that state, resident or domicile of that state. The president said, you can't do this. So there were several, few instances, but where bills were withheld. But as my Lord Justice Narasimha says, the longest period was the postal. And it has its own history. I will not go into it. But some good justification. Years back, it's not a current.
Keep reading.
No, I am not trying even. I don't know, my lord. Therefore, I am not trying.
You'll soon learn that art.
Now, my lord, comes Article 155. I'll take some time, my lord. I'm not repeating your lordship's.
No, we are not saying so. My learned brother asked, because there are only 7 minutes left.
Lord, the next point is an important point. Can I start tomorrow?
That's what.
Because 155 is appointment of the governor. What is the significance? What is the role envisaged? What is the responsibility he is expected to?
We understood your desire, and so accordingly, tomorrow.
You also have to now do some other work for at least the next 3 hours.
Yes, yes. Your lordships need not read this. Otherwise, my lord, it would be very boring. I am going to read this.
No, we are having, at least 3 of us are having some other duties.
I leave it to your lordships, but in a presidential reference, except state and the
Private parties.
The exact opposite of that.
There is one IN 19.
We are given the deadline, we should have filed prior to that. If necessary, we will hear you.
grateful to you.